पूरा कोर्ट रूम जे पॉलीप्लास्ट है ना
that we have heard and judgment will be pronounced in that case. Don't say. Huh? Or you write an order and sign it and give it to Mr. Rao. Huh? Yes.
Commercial Court CRP, my lord, 314 of 2020.
Urgency.
Urgency, well, because of stay of all further court is in COS.
When have you filed vacate petition? Is it pending?
My lord, I am for the petitioner, my lord. My suit is stalled. So that's the reason, my lord, we are seeking.
No, no. Have you filed any vacate petition?
I am the revision petitioner, my lord. So because
You
of.
have got the stay.
Yes, my lord.
So have you filed an application for early hearing? No.
Actually, my lord,
Please
this
file.
has to.
You want final hearing, that can't be done by way of a mention memo. Next. Yes. Ah.
I have filed an amendment petition now.
It will be called, madam. Don't worry, it will reach. There is no problem. Yes.
The amendment petition is not listed with me.
It will be called. Get it. This thing is covered. We will not, it's covered by judgment. Fine.
Subject to your kind permission.
1 minute, Mr. Madam. Tell her what is it. These people make all sorts of. Tell her that some objection it has, madam.
We have resubmitted the law.
Today.
Yes.
Resubmitted, get it along with that. It will be yes. Yes.
Medical admission, lordship, petition.
1 minute. Mr. You are a ex-judicial officer, right?
Yes, my lord. Yes.
And patience is the virtue of every person who has held the judicial office. Like a child, you are getting impatient. We said from this direction, we will, of course, permit you to mention. Don't get impatient. Yes.
Petition has been denied EWS quota, lordship, in the medical counseling.
EWS court.
Economically weaker section quota.
Ah.
Petition has been denied, the lordship. At least
Ah.
second phase, she is seeking a direction to consider.
Tomorrow.
Obliged.
My lord, item number 27, my lord.
Ah.
I want to file some of the additional documents, my lord. You may kindly
You want-
post this matter
Ah.
after 2 weeks, my lord.
All right. See, there was no urgency and you are.
No.
Ah.
There is an urgency, my lord.
14% prays for adjournment in order to enable him to place on records certain documents. List after
My lord.
weeks.
Again, I am also filing it.
They don't file. This is nothing.
Whatever it is, please file it into registry.
Registry and you wanted 2 weeks. We have made it. Yes. 2 weeks. Yes, Mr.
Right. In my automatic illegal removal without
Huh?
ongoing issue, previous honorable CJ advised me hereafter you don't file any more petition. You go for negotiation or mediation settlement with the High Court Legal Service Committee. So I made a representation to the High Court Legal Service Committee, but they told.
No, nobody advises, right? That this thing, if somebody tells you in good faith, it's not, that doesn't mean that you should quote him after the honorable judge has left the court. Don't say that previous Honorable Chief Justice advised. The job of a previous Honorable Chief Justice was not to give advice to you. He was here to run the administration of the High Court and to decide cases. Right? No, nobody gives advice. Huh?
Barring him from filing any further action.
This is the
Then tell him. All right, fine. You know the order, right? You know the order passed by a division bench of this court in your appeal that no interlocutory application filed by you shall be entertained. Correct. Next. You know it. Yes. Yes, madam. Yes, madam.
Related to lunch motion, and also I have the petitioner hearing has cleared the
Huh?
also challenging the GO 72
Medical,
BPS medical
is it a medical admission or
medical UG admission.
UG?
Rule 72.
072 consequence.
Rule 72. What is rule?
Township, the petitioner hearing is challenging the 50.
Mr. Rao, have you got the copy of this petition? What is the challenge? She is unable to.
72.
72, we don't get it. What is the rule under challenge? Rule 33B,
Yes.
33B or 33C? E.
It has been moved.
This is something new to handle, Mr. Rao, for you as well as us. She doesn't know, see, she doesn't know which rule has been challenged. Which rule, madam? Simple.
DE also it has been now.
Tomorrow.
100% quota.
100% quota in for local candidate
Beyond the
beyond 2014. Simple, madam. This is what you should say. Lunch motion and everything you said except this relevant thing. GO 72 tomorrow. Yes. You supply a copy to Mr. Rao in advance. We'll take it up tomorrow. Yes. No, it will be called 16. Will be called. We have stopped this practice of this out of list mentioning because we have received complaints from the lawyers that behind their backs the adjournments have been sought. So we have stopped the practice. Yes, next.
May I please, Lordship?
In this, both the lawyers are there. Yes.
May I please, Lordships? Lord, this contempt appeal is being filed. Lord, challenging the orders in CC.
When did you file review? When did you file review petition?
Review petition, my lord, 2022, my lords.
2022 has 365 days.
Within
You
the,
cannot file on 365 days review petition.
it was pending, my lord, it was numbered and pending. My lord, the,
Answer is, Mr. If you don't know, you say, I don't know. The answer is a specific date. When did you file review petition? Simple. You,
Yes.
if you don't know, you say, I don't know. Then we will grant you time. Correct. This contempt appeal is filed against an order dated 3/7/2023, passed by the learned single judge in exercise of jurisdiction under section 10 and 12 of Contempt of Courts Act. Paragraph when a query was put to learned counsel for the appellant as to when the appellant filed a review petition, learned counsel for the appellant stated that he is not aware about the date of filing of the review petition. He therefore prays for adjournment to enable him to apprise this court with regard to date of filing the review petition. List after 2 weeks.
August 2022, my lord, is date.
August is not a date. Again, August has 31 matters, 31 days.
Lord,
That's a wrong statement. The review affidavit was signed deposed to in March 2023. We were only wanting to know what date. Yes.
Mister, if you don't know, say better not to. Instead of making a false statement and being caught. And again, this is a contempt appeal. You should be doubly cautious.
Lord,
Along with your client, you will also face.
Lord, I'm sorry, Lord.
Sit down.
I'm sorry, Lord, for the convenience.
Don't. if you don't know, it is perfectly all right not to know a thing, but say so that I don't know. And I need time.
I do not know, my lord. I'm sorry. my lord.
Correct. Don't do this.
This is the earlier, my lord. I was not the son.
Study. Now you have been engaged to study the file, right?
Yes.
Please study. Yes. Yes. Please find out.
Correct.
Yes.
Item 2. Yes. Call. Madam. Item 2 called.
Item 2, Miller. May it please.
Yes, please. Yes, please.
I seek the Lord's leave to appear in the virtual.
Yes.
This appeal, my lord, is filed under section 13 of the Commercial Courts Act. My lord,
We will,
item 2.
Mr. Senior Counsel, Mr. Raghuram.
Yes, my lord.
Yeah, we will send for the records and issue notice on admission.
Very good.
Right?
My lord.
But you know,
Order, my lord, if
what
lordship
is this?
uses,
No, it's
usual
a,
order lordship can consider, my lord, it will be useful for usual law, since a money decree, lordship can consider usual order, my lord,
50%.
thumb rule of this honorable court, lordship knows half
50%. That's so I have also been following. 50% will you deposit?
Yes, my lord, yes.
And they will be permitted, of course, to withdraw.
That you may lordship permit after they
No,
file
no.
reports.
No. So that what we'll do, Mr. Raghuram, is that we'll issue notice, hear the other side, and then follow the thumb rule. Correct? That
Very
can
well,
also be an option.
Very well. Doesn't matter.
Mr. Raghuram, learned senior counsel for the appellant, this appeal under section 37 of the Arbitration and Conciliation Act has been filed against an order dated 26/8/2022, passed by the Commercial Court, by which petition filed by the appellant has been dismissed. Paragraph. Learned senior counsel for the appellant submitted. Learned counsel for the appellant submitted that the Commercial Court ought to have appreciated that what is your submission, that the arbitrator has
they have
traveled
not
beyond the
followed
scope of the agreement. The arbitrator
Paragraph
has,
34 of
Huh?
not following whether there is a illegality or not has not been considered.
all
but it
right,
is
learned
considered
senior
like a
counsel
partial-
for the appellant submitted that the trial court, while the Commercial Court, while deciding the petition filed by the appellant under section 34 of the Arbitration and Conciliation Act, has not appreciated whether the award suffers from patent illegality as
Yes.
patent illegality. Full stop. In paragraph, let the office is directed to secure line below. Office is directed to secure the record of the Commercial Court. Let the appeal be, issue notice of IA number. What are not IA is what IA.
There are two IAs, my lord, IA 1.
1 of 23 and 2 of 23. 1 of 23 and 2 of 23 to respondents on admission as well as IA so and so, right? Let the appeal be noticed before admission, whatever you write. Let the commercial appeal be listed for consideration of IAs, pending interlocutory IAs after respondents are served. Immediately respondents are served.
Obliged.
So that it will be.
He places a glance. He places a glance on this. He is relying or we have.
This case, and this is on extension. So that it will be easy for you.
Yes, next.
It's actually come to education.
This matter, my lord, in the constitution, Ravichandra is appearing, my lord, he is unwed today. Requested tomorrow, my lord, they be accommodated tomorrow. Mr. Senior Counsel Ravichandra is appearing in this matter, he is feeling unwed today. And I
Mr.
requested
So-and-so,
tomorrow.
not tomorrow, maybe tomorrow is what?
Yeah.
Not tomorrow. Learned counsel for the appellant press for adjournment on the ground that the arguing counsel is unwell. List after 1 week.
I could move in. In the day.
See, one case to appropriate everyone. Medical is too much, right? One day should have been more. Good. Yes.
Yes, Your Honor. So the writ appeal preferred against the order of the trial refits
Right.
number 16017, my lord.
45A, appeal.
Appeal, my lord. Against the order of the learned single judge.
No. Learned single judge refused to entertain your petition because of availability of an alternative remedy of appeal.
Yes, my lord.
We understand this is an appeal.
Yes. So, my lord,
Under clause, so why should you not file an appeal?
because, my lord, there are substance, I have raised some question before they throw additional affidavit, my lord. That was not considered at all, my lord. At least single point of the additional affidavit is not considered. Yes, my lord.
File an appeal.
I'm dealing only civil miscellaneous civil works, generally in the defense sector. Company name was registered as the.
No, why can't you file an appeal under 45AA?
Because I am not having any work plus since a long year.
That can be gone into by the tribunal, the appellate authority, first appellate authority. Please look at para 3 of the order. It is absolutely correct.
Yes, madam.
I have cited a judgment, my lord, which even after having the.
Once the alternate remedy is there, these are all
Ordinary.
special enactments, you will have to go there.
Kindly see the order placed by before this honorable court, my lord, which is the page number
You go file an appeal, miss.
56, my lord.
File an appeal.
I am requesting my lordship to see the order given by the Supreme Court in this regard, even after having the order.
No, the Supreme Court has granted you liberty to not to file an appeal and keep on filing writ petitions.
Yes, my lord.
Supreme Court has granted you liberty to straightway file writ petition before taking recourse to the remedy of appeal.
Not only, my lord, but my lord, without considering the aspect of the
Yes.
ESI Act, they passed the order. Even whether I will come under the ambit of the ESI Act.
Yes. What is it? Read.
Page number 26, paragraph number 4.
The authorities have not followed a settled position of law. That is why.
Before answering the questions, we feel the
No. This is an authority for the proposition that notwithstanding availability of an alternative remedy, the court can entertain a petition under Article 226.
That's why, my lord, I'm requesting my lordship.
We know that, but the remedy is discretionary. In the facts of the present case, we do not find any ground.
At least, my lord, let them consider whether I will come under the ambit of the ESI Act or not.
That
At least the
authority, you can raise that objection before the authority.
The London Single did not express any opinion regarding that. I filed an additional affidavit by raising that aspect.
File review file.
Even that was during the time of argument, I raised it.
If a particular ground raised by you has not been considered, AIR 82 Supreme Court 149 says that you have the remedy of filing a review.
Yes, my lord.
So you withdraw this if you want to, in case otherwise, if we pass an order, choice is yours.
Just, my lord, whatever the count I have raised, my lord, at least your lordship can consider and make an opinion regarding that aspect, my lord, whether I will come under this arbit to issue notice or order.
Fine. Supposing if we answer the grounds, what happens to your appeal? Nothing. Appellate authority is subject to jurisdiction of this court, right?
Yes, my lord.
So if we decide your issues on merits, then appeal, he would be lost. He would lose the appeal here itself without you going there. We can't do it. This intra-court appeal is filed against an order dated. Order dated 4th July 2020-23, passed by the learned single judge, by which writ petition has been disposed of with the liberty to the petitioner to avail of the alternative remedy of appeal under section 45 capital A of the Employees State Insurance Act 1948 paragraph. facts giving rise to filing of this appeal briefly stated are that the petitioner assailed the dated which order? Order dated 19/1/2023, passed by the passed by Assistant Director, passed by the Assistant Director, Employment State Insurance Corporation in a writ petition before the learned single judge. Full stop. The learned single judge inter alia held that the petitioner has an alternative, petitioner has a remedy of appeal under section 45AA of the Act, and therefore permitted the petitioner to file the appellant, permitted the appellant to file an appeal within a period of 2 weeks from the date of receipt of copy of the order. It was further directed that in case appeal is filed within a period of 2 weeks, the appellate authority shall consider the same in accordance with law. The appellant, however, instead of filing an appeal, has filed this intra-court appeal. Paragraph. Learned counsel for the appellant submitted that this court can exercise the jurisdiction under Article 226, notwithstanding the availability of an alternative remedy. In support of aforesaid submission, reliance has been placed on decision of Honorable Supreme Court in Messrs. Godrej Sara Lee Limited, page 25, madam, versus so and so. 2023 live law within bracket SC bracket close page 70, not page 70. Full stop. We have it is also contended that all the contentions urged by the appellant may be answered by this court. Paragraph. It is right law that jurisdiction of this court under Article 226 of the Constitution of India is discretionary and normally is not exercised. Normally is not exercised in case an alternative remedy is available to a party. Full stop. This case doesn't fall in any of the well-food. The case of the appellant also does not fall in any of the exceptions carved out by Honorable Supreme Court in Whirlpool versus so and so Registrar of 1998, Volume 8 SSC, page 1. Full stop. Therefore, we are not inclined to examine the submissions and examine the issues raised by the appellant in this appeal, as the same at the first instance have to be adverted to by the appellate authority. Full stop. However, since the appellant has not filed the appeal, we permit him to file an appeal within a further period, within 2 weeks from today.
I can find selling GP to cooperation, GP for.
In this petition, my lord, the appellants are questioning the order passed by the land single judge, my lord, directing the respondent authorities to declare the results, my lord, declare the results which they questions in the writ petition, my lord. The Red Cross Society of Hyderabad district, my lord, notified for elections, my lord, on 10/7/2023, my lord.
You are petitioners, right?
Members of
You are petitioners before the learned single judge. You are
petitioners in the lower court, my lord. Learned single judge.
Don't, Mr.
My lord.
This is only this thing. It is a forum where we correct our mistakes. Don't, I mean, the learned single judge is not subordinate or lower. You are addressing lower. We will tell Justice Reddy your name that he was addressing your lordship as lower court.
I'm sorry.
No, but rightly or wrongly, he admitted that he should have gone to lower court. District judiciary.
My humble submission Then the law prescribes certain procedures, my lord, have to be adhered by the authorities while exercising powers under the statute, my lord. Here, Lord, kindly see the procedures contemplated for conducting the elections, my lord. Page number 129 of the material paper.
No, which provision, this thing, which statutory provision prescribes for holding election of Red Cross Society? Which provision of law?
My lord, Act is provided in the Act is
Mr.
promulgated.
Article 226 remedy you can resort to for violation of a statutory right. So first of all, you have to show 1 minute. Listen to us. Show violation of statutory right. Second, you have to show that this stage of election, the court can interfere when the result has been declared. When result has been declared, when?
Yesterday, your lordships, but rather Saturday, your lordships.
Saturday is the date.
20th, my lords. 20.
20th September,
Yes,
August.
August, yes, your lordships.
It has been declared. So at this stage, what can we do? Number 3, just a minute. So for election of which law of our country or state legislature or parliament provides that election of society, Red Cross Society, should be held in this way? Your writ petition is pending. Interim order, the result have been declared. You go and contest before learned single judge. And thirdly, 3 questions. 3 questions, please answer, and you will get the answer. If you answer, which law provides for holding of election of Red Cross Society? Which statutory law? Right. Second is, tell us that at this stage, even after declaration of the result, we can restrain them from functioning as office bearers and elect you as this thing that you should do it and handle the budget and finances of the society. This is lighter weight, not your prayer. This is the whole thing is about. Number 3 is that against an ad interim order in an intra-court appeal, why we should interfere? 3 questions you answer.
My lord, in this matter, my lord,
Statutory, no battle. This is not a battle. This is not a battle. Contest. Elections are.
the orders passed by the lunch single judge only, the results are declared, my lord, which I am questioning, my lord. Lord, the lunch single judge ignored the law as well as the president
No,
on him, my lord.
Mr. Counsel, either you should say that I did not understand the questions posed to me. Then we will repeat once again. So we will pose one by one. First question is, under which provision, statutory provision, election of Red Cross Society is held? Which law? Enacted by Parliament or a state legislature?
Enacted by Parliament, my lord, 1992 Act.
Which rule? Which rule?
I filed it here.
Where is that?
Page number 129. 129.
Yes.
Lord,
1 minute. Under which provision this has been 129 is enacted? You have not told us the name of the rules.
Indian Red Cross Societies Act 1920, my lord, which is adopted by the Parliament in the year 1992, which is in force in the country, my lord. Various high courts, including the Supreme Court, my lord, in gas tragedy, your lordship is aware. The Supreme Court has taken.
Mister, we are not saying anything. We are asking you under which statutory provision the elections have been held. Which is this thing?
For conducting the elections for
Which statutory rules, Mister?
Indian.
Like elections of your advocates association are also held every year, correct? So under which provision of law an election is held? Because see, if please understand, Mister, and we have reason to believe that you have sufficient backing in the this thing profession, and you can understand. If a election has been held in violation of a statutory provision, perhaps a writ, we don't know, would lie despite election petition. 1 minute, listen to it. And if it has no statutory backing, then what the learned single judges has held, that go to district court.
My lord, kindly.
This answer is simple. You tell us.
Just a minute, my lord, whereas
Shall we appoint any amicus to
Division
tell
bench
you?
of the Kerala High Court has interfered in the elections conducted in regard to Kerala.
That is not Supreme Court, right? It's
Yes,
not binding.
even
Not
though-
binding.
Lord, 165.
Yes, sir. If you don't want to answer, we will say that you are, despite questions being you put, you are not answering. Please answer which provision, this page 129. What is the act, rule? Nothing. You have not said anything.
From one. Lord, at page number 97 of the material paper, my lord, I filed the Indian Red Cross Society rules for the state, union territories and district branches.
Which is
Can you say at page number 97?
97. Yes. Where is it? Indian Red Cross Act. This is blank. What is this blank? Page 99 blank.
That was supplied to me, my lord. That was given to me.
No, we are asking you what is, it is supplied to us also blank. So we are asking what is the blank. Perhaps you should know what is blank.
That is chapter 1, my lord. Chapter 1.
No.
Blank, sorry.
We are asking what does blank mean? Indian Red Cross Society blank. Office of the branch located at blank.
In the book itself, the same. In the book itself, that is reflecting, my lord, which I copied.
You don't know that. You don't know what is this blank about, right?
Right.
So. So, so where is that election thing?
Kindly see at page number 129, my lord.
129.
Yes.
Yes. Annual general meeting.
BA, my lord. This is the procedure. After completion of the term of the district management committee,
Acha.
the district collector and president will appoint one election officer to conduct the elections for the formation of the district management committee, my lord.
Arey, mister, you have not filed the whole of the rule. It is incomplete. 129, after 129, 130 is a letter proposed amendment. Do you have the complete set of rules?
No, this is only given.
Please file. This is like, it must be providing for an alternative remedy of after elections are held, a remedy of filing an election dispute to which you don't want to resort to. This rule incomplete rules. Learned counsel for the petitioner fairly submitted that that he has filed incomplete rules framed under Section 5 of Indian Red Cross Society Act 1920 and praise warrant is granted. How much time? 2 weeks?
3 days. 3 days.
3 days. 3 days time to, we don't know, 3 days time to enable him to file a complete set of rules. List thereafter.
Right. GP per annum.
I'm just passing on the list of the dates and short submission, Madam.
Correct. Right.
The list of the dates have just passed on. Short note on submissions also be given. The short issues that were, the dates were.
The repetition you look at this thing. Stem cells. So, but that was not, so they issued this for years. Because we did in 2008, the council, the people. Yes.
That sequence of the dates were sequence, my lord, were not correctly recorded. That's the reason, my lord, was attributed, the delay was attributed to the repetition appellants who did not take up action in time. But for example, my lord, the application, my lord, was made to the authorities in 2008. And my lord, the GHMC lord, wrote letters saying that it has to get a clearance from the irrigation department that is not within the FTA. That was given only in 2011. That was given only in 2011 when those proceedings. And
So after 11, what did you do to for 7 long years?
no, 14 they issued the first notice. But after that, right. 2014.
No, what did you? This land was allotted to you for construction of a hospital, in which poor people a quota you were supposed to 5% free of cost. Object was that. So supposing 2011 up to 2003 where you were allotted, right?
2007, my lord, the conveyance, registered conveyance deed was given.
2007, right? 2007, let us assume it was allotted. There was a delay on their part till 2011. Right?
2011.
Their part, agreed. What did you do from 2011 till 14?
2011, November, my lord, they issued the proceedings. And March 2012, they paid the money.
So
they paid the money.
What did you do for 2 years?
Right. From 2012 to 2014, my lord, due to agitational atmosphere, my lord, construction could not take place. I explained that. And we were, they were paying the money.
So then what happened in 2014?
True, my lord.
Then show cause notice was issued in 2014. Obviously, Mr. You didn't do anything from
No, but
2012,
that's the
12,
reason.
13,
The
14.
additional affidavit we had filed saying that 73 crores was spent and the work was taken.
What we feel prima facie learned senior counsel that there is a mix up of dates also, right? As you say,
Yes.
and you have filing additional affidavit. Better remedy is to approach the learned single judge by bringing these apparent mistakes, etc. No application
May I make one?
because you are relying on some additional
The Lordship
submissions.
feel that bad, I'm obliged, obliged.
That's what we feel. That I mean, factual aspect, date,
And
no application of law. He
I
will
live-
realize that it's
beyond that.
better. Huh?
And I thought the Lordships are.
No, and you know, but you are.
No, I'm
You
not.
will decide, but we will not look into your additional submissions, right?
Right.
Then you bring it because you are saying that there is a mix up of dates. Probably learned single judge should look at the first instance. We are always available.
Well, but only one request, but yeah, I don't know whether I can make this submission. The Lordships are remanding me back or asking me to file a review.
Asking you to file a review,
I leave.
right? So it should be our order or you will do it.
Lordship may make.
We will pass an order. Yes. This petition, this. Correct. 240. So it's better that we are not entering. This intra-court appeal has been filed against an order dated 14/7/2023 passed by the learned single judge, by which writ petition preferred by the petitioner, in which challenge was made to an order dated 7/3/2018 asking the petitioner to hand over to surrender the possession of the land in question, comma, has been dismissed. Paragraph. Learned. We have heard learned senior counsel for the petitioner submitted that in para 23, learned senior counsel for the petitioner, while inviting the attention of this court to para 23 of the order passed by learned single judge, submitted that the dates in the aforesaid order have been mentioned incorrectly. It is while inviting the attention of this court to para 23 and 24 of the order submitted.
25.
cases merely because counsel is different. We are
Apologies
bound.
for insisting, Your Lordship. I'm only seeking permission to put forward a five-judge bench judgment of Supreme Court, Your Lordship, for Your Lordship's consideration.
You seek modification by 5-judge bench that the petition should be allowed the day it is filed. This is what
I endeavor, Your Lordships, is that there
we
is
have,
a
Mr.
direction.
Please understand, we have passed an order in several other writ petitions, including yours. So every day, if you keep on learning something new, study, then you cannot say that every day file petition and then say, now this constitution bench, now 9-judge bench, now 13-judge bench in Keshwanand Bharti, I want to bring to Lordship's notice. What 95 supplement 1 SSC, Siliguri Municipal Corporation, the court says that there the doctrine of parity and consistency applies in interim orders also. So we are not here to suggest, but let this order be passed in case you feel it is contrary to law or need any modification. File an application, Mr. Rao will get an opportunity and we will decide it, or you can, against this order also, you can go to Supreme Court or you can file modify.
My only endeavor, Your Lordship, is to draw the attention of this court to the judgment, Your Lordship.
In your cases only, Mr. Order, this order has been passed.
Obliged.
Why did you not bring it to the notice? Shall you say that, we record that he says that he was not prepared at that time of time and did not know facts of the case? Now he is prepared. Shall we say in your praise? Every time when the matter is called, it's not that you will take everything in your order. In your cases, we are following the order. You have the remedy of filing a modification or challenging it before Honorable Supreme Court.
Obliged.
We don't want to go beyond this. Thank you.
Obliged.
Yes.
The petitioner could not make an application for B and C category. Page 22 is Your Lordship, sir.
He is
Page
very.
22 order.
Page 22.
Page 22, Lordships. Make a
So Mr. Rao is very liberal when it comes to management quota. He says everything we will consider, doesn't oppose C. Not opposing your prayer. Mark the presence with consent of the parties. The writ petition is admitted for hearing with consent of the parties. Same is heard finally. Page 24 is the order, right, madam? This all accordingly. Huh? Final order? Disposed of. You have objection? Then?
May please, Lordships.
Yes, Mr.
Let's the petitioner before Your Lordship.
So everything is. Everything 7 to 15 same. I haven't seen. That's why I didn't know. Yes.
May please.
This is rule 3.3.
Let's.
Reserve.
Local status. Local status, let's.
The batch which we heard and
Intermediate plan Karnataka.
that is why batch what we heard and
Oh. So that's the qualification, Mr. Rao, intermediate from Karnataka. Huh? So they are entitled to relief, right? Reserved for orders. Mark the presence with consent of the parties. You call who the person who took this dictation in this batch? What? Yes. She is here. I'll be just now. Call. Or PLN. PLN. What, Mr. What did you do? 1 to 10th from Hyderabad.
Yes, Millets.
And 11th.
11th will from Karnataka Millets.
Which place? Karnataka.
Kalburgi. That is Gulbarga Millets.
Yeah, Gulbarga. Both.
Yes, Millets.
Gulbarga, right? 220 kilometers away from here.
Yes, Millets.
All right. PLN is coming. So, Mr. Rao, this also goes with the bunch. We are only adding the facts.
Yes.
That was the most appealing argument, Mr. Rao's argument, most appealing to both of us, that though the candidate is a local candidate residing in Hyderabad, but in order to claim the benefit, he must not study from an educational institution approved by the government. So,
OCI card. It is something like your OCI. If you go out, you will become.
Where? No, they are taking water. No, but this thing. They will review. That we are waiting because. In the meanwhile, Mr. What is next item? 1 minute, you stay here.
Yes.
Just stand here only. What is the next? 12. NRI.
No.
12. 12, same millets. Or same. What? 1 to 10 millets. Millets. Last 1 to 10 from?
12 from Karnataka, Kalburgi millets.
1 to 10.
1 to 10 Hyderabad only millets. Millets. These millets. 1 to 10 from the Hyderabad millets, 11 and 12 to Kalburgi.
Same, right?
Same millets, birth certificate and caste certificate issued by the government of Telangana millets.
Done, closed. Yes, reserved for orders. Why should you come with this, Mr.? So, 2 cases you have to add. Write down. Item number 11. Facts, right? Facts. Array, Mr. Look here. Facts, we have written facts. There add one more paragraph. Facts. In facts, WP number 23601/23 and WP number 23605/2023. The facts in both the cases are similar. Full stop. The petitioners have passed 1 to 10th examination from which place? Which one?
Permitted to represent Mr. Zulfikar.
NRI.
My apologies, my lords. Because he is held up in Delhi. He missed the flight, my lords. I am representing on his behalf.
No. You are here.
Yes,
we
my
are
lord.
concerned with you.
Yes, my lords.
You missed the flight.
Mr. Zulfikar Alam, the counsel on record.
That's fine.
Yes, my lord. He requested me to submit that, my lord, though the petitioner is not an NRI student, but her only request is if the NRI seats are not fulfilled, in that case, she may be considered. She is willing to pay on par with NRI students. That is the only request, my lord, she has made.
Under 2017 rules, she can't be treated as NRI. She is saying so.
Yes.
Now what? That is a matter, don't involve the court, right? Because we are bound by rules of law and this thing we will have to hold.
Yes.
But Mr. Prabhakar is very magnanimous. He can,
because
you approach him.
My only
If there is a vacancy, if he can admit, we don't know, but don't involve us. We will have to hold that you are not entitled to this prayer.
No,
because we will have to examine your entitlement with reference to rules only, Mr.
Yes,
Do you understand?
Very true.
Very true. So the best course of action would be to withdraw this with the liberty to approach the university. And Mr. Rao, you have already approached.
Yes, my lord.
We will ask you take a call on this.
Yes.
22nd August 2023 letter.
Yes.
In this, yes, madam, with whatever. Mark the presence with the consent of the parties. The petition is heard finally. In this writ petition, comma, the petitioner who has appeared in NEET UG 2023, comma, seeks a writ of mandamus directing Kaloji something whatever university, Kaloji Narayan Rao University of Health Sciences to treat the petitioner as NRI, as candidate belonging to NRI quota. Paragraph, learned counsel for yes.
My lords, I beg to appear for the petitioner, my lords. We're being led by a senior counsel who's held up before the Supreme Court. My lords will call it tomorrow. We've informed the other side as well, my lords. The other side is
Learned counsel for the petitioner prays for adjournment that the on the ground that arguing counsel is not available. List after 1 week.
I'm obliged, madam.
Mr. One thing, you are a young person, so we are not concerned with the location of the senior counsel.
Apologies,
He
madam.
can be in Delhi, Paris, London, New York. Doesn't make any difference. Hague, for that matter. So don't say that. You say that on account of personal difficulty is not available.
Very well, madam.
Don't threaten us by saying disease before Supreme Court.
Not at all.
It doesn't make any difference.
I
To us. we are insulated from all this, right? Don't say that he is busy before Supreme Court as if has gone to.
Very well.
You are a young person, that's why we told you. You say that not available on account of personal difficulty. Understand?
Apologies, my lord. I'm obliged.
Yes.
My lord, I'm from about petition council, my lord.
Ah.
My lord, actually, this writ petition about 17 illegal crusher missions in the village of Chinnaravirala village.
You are not implementing crusher machines. That's the problem.
My lord.
You 17 crusher units, who will implement? In para 3 of your affidavit, you have given all details. They will have to be implemented in the writ petition. That you are not doing. That's why office objection.
Yeah, yes, my lord. We'll implement. We'll implement.
How much time?
Within 2 weeks, my lord.
And who else? Counsel for the petitioner praise fund is granted 2 weeks time. Tell the pollution control. That's the way to be smart, Mister. You have the notice. By the time the petition comes up, he should take action and let us know this is what we have done. Instead of accepting notice, telling us I appear on behalf of Pollution Control Board and then 3 weeks time to file counter.
Representations are pending, my lord. Orders can be passed. Meanwhile.
That's what we are telling Mr. Praveen Kumar. Mr. So-and-so learned counsel for the petitioner. Praise fund is granted 2 weeks time to enable them to implement the owners of the crusher units which are allegedly carrying on illegal activities on the lands which belongs to the petitioners.
No, my lord, it's a public interest litigation, my lord.
No. So land belongs to whom?
Chinnaravirala village, survey number 268.
Survey number 268 and whatever. Lands mentioned in para 4.1 of the writ petition. Just after 2 weeks.
I'm appearing to.
We'll admit it. It will have to be heard. We'll admit it for hearing.
I have filed vacate stay application, my lord.
Oh, yes. That, yes. Correct. What do you say? Why? Yes. What is this?
Scope of the appeal is very limited, my lord, under section 37. My submission is I've been waiting for the past.
No ground is made out.
Yes, my lord.
What is the stay?
Lord, it was the arbitration seeking specific performance of an alleged agreement of sale method. That has been granted to them. So
No, you don't want order sheet. I want. What state?
If I kindly see the
1
agreement,
minute.
the subject matter is a specific performance claim, which has been granted, my lord, and 34 court upheld it. So, my lord, if there is no stay, then it is as if the whole matter is over.
2019 is the date of agreement.
Right, please file an application for early hearing. We'll consider this is 23 appeal.
Application.
See the list of final hearing cases. People are waiting since 2005. The commercial appeals deserve preference, but at an appropriate time.
A shorter date may be given.
Shorter, no date is being given. You file an application.
I have filed an application.
Vacating stay, we will consider you. Pass an order. What do you say? Why it should be vacated?
By submission, my lord, neither the award of the arbitrator and the order of the district judge are against public policy, and neither they are both
does not fall within the purview of section 34. Therefore, stay should be vacated. Right?
37.
That's the Mister. That's the main argument, right? That's what he said, senior counsel, that if the stay is vacated, nothing survives.
Let there be an.
You see, you will sell the property if the stay is vacated.
May I make one submission, my lord?
What happens then?
May I make one submission? They also, the appellant also may be directed not to create any third party interest.
It's always there.
That's always number 50.
Let there be an order of the court.
Yes.
Obliged.
So we will pass this order only on your IA, right? Heard on IA number 2 of 20, admitted for hearing, madam. Then heard on IA number 2 of 2023. After hearing learned counsel for the parties, it is directed that the appellant also shall not create any third party interest in respect of the subject property, nor shall alter the physical features of the subject property. Full stop. To the aforesaid extent, comma, this will admit for promotion. Heard on the question of admission, the petition is admitted for hearing. Arey, Mr. Rao, you know, it has to be admitted, right? We will hear you. This is for admission. Mr. Hanumat Rao, learned counsel for the appellant, heard on the question of admission. Appellant appeal is admitted for hearing.
This is a matter where
2 minutes, if it can be disposed of, we will do it right away. 2 minutes.
I am passing on for your lordship's
No, no,
consideration.
this can't be done in 2 minutes.
No, your lordship may kindly accommodate me for 10 minutes. I will come
No,
to
no.
my.
Mr. Rao, some other day, it is for admission, admitted for hearing. 23 appeal. Admitted for hearing. Please move an application for urgent hearing. Definitely we will hear you. Yes. Which 20? 21. Yes. Our pleadings are complete, right?
May I pass on your lordship? This
Petition is admitted for hearing.
may I pass on this
Reply.
list of for submission.
Arey, you give it on that day, no, Mr. Rao.
But your
It's
lordship.
so attractive blue color. Give. Yes, all right. Keep
This
it.
matter arises of purple and ceiling where act is the proceedings have been abated and they are interfering in the construction now.
So we thought it's a claim for promotion. No, it's correct. We will hear you shortly, Mr. Please file an application any date. Yes. Claim for promotion admitted for hearing. No, he says covered, then file an application, Mr. Everything. We have to apply uniform stick, a yardstick, like if 2 minutes it can be disposed of, he says covered by Supreme Court, we will not just now pass an order. Covered by Supreme Court. Please file an application for urgent hearing, we will decide. Challenging inaction of not taking.
Well, this is a writ petition filed, the SA order is not implemented.
No, so SA order is not implemented, SA order is passed by whom?
Debt recovery tribunal.
So debt recovery tribunal has no power.
Has no power to.
Where is that?
Well, there is no power.
No. So debt recovery tribunal, then High Court is the executing authority for. No. Just a minute.
There is no remediless.
No.
Either remediless, parties are remediless.
We are trying to understand, right? Yes. You want to say that once an order is passed by the debt recovery tribunal, it has no power to execute its own order, and a party in whose favor an order is passed is remediless.
Yes.
Correct?
Action has been set aside. Sale certificates.
Which act?
Action has been set aside. Measures were challenged before the DRT. Measures have been set aside. Sale certificates have been set aside. Thereafter, again, the court is not saying DRT. Fresh action to be taken. That is not being taken up. We have approached this honorable court. And the act, there is no execution mechanism.
Surface Act, right? Surface Act.
Yes.
It is not even a civil court. DRT.
Yes.
Not even a civil court, we are asking, Mr.
The traffics of the civil court, yes.
Then?
But as for the SARFASI is concerned, it is only an appellate authority under section 17. DRT is it.
No, you examine this issue, Mr. I don't think it admits of such an easy blanket statement that no power. It will be this
because
thing.
DRT is an appellate authority under the SARFASI Act.
No, are you sure that you are correct in making?
Absolutely.
So we will have to make a research then, because you are not assisting us. We will make a research and hear you some other day.
No, please.
We will hear you some other day because you are not assisting us. You want us to make a research and decide.
I said against section 13 measure appeal lies under section 17 of the Act.
Yes, Mr. Senior Counsel, we want an adjournment if you want to hear it that way. We cannot allow this petition that on your statement that there is no provision for execution. We can't allow this.
Lordship has just said
Recovery tribunal is a toothless tiger. We are not
Section
prepared to
17,
deal.
Your Lordships. Section 17, Your Lordships.
This issue must have been dealt with somewhere by some High Court, Supreme Court, we are sure.
Subject to correction, my lord, other councils are also there, my lord, it's not dealt with.
We'll examine it some other day.
Finally.
Which provision you are referring?
Appeal is section 17.
It's something new that.
Well, there is a one section, my lord, which may, my lord, section 19 may.
So you will appreciate that it requires some deliberation, some research on your
Your Lordship is saying that, my lord, I was not assisting it. I can only section 19.
No, don't make it. Not assisting means it's a way of saying that because you should have, we were only trying to convey that this proposition, which has been argued for the first time before at least me, that debt recovery tribunal has no mechanism to execute its order.
Yes.
So therefore, my mind, speaking to my mind, I thought that it requires some debate. So, Mr. Counsel, you appear for the bank. Please assist. Please assist. Because you are at stake. If it is held that debt recovery, you are gone. Because now we will be giving supposing if his argument is accepted, there is no case law, is reference to statutory provision to say debt recovery tribunal has no power to execute its order. What will, if supposing if we hold so, then what will happen to you? You should, in any case, it's a question which must be of importance to you. Right?
Yes, Your Lordship.
You study it and then tell us. So, learned senior counsel for the appellant, this writ petition has been filed seeking a direction to the respondents to comply with the directions issued by the debt recovery tribunal as contained in the order dated. Which is the order, Mr.?
Order dated, SA 300. 27/2019.
27/9/2019.
Which is confirmed by the Honorable High Court.
20th
29th July.
29 July 2019. Paragraph. Learned senior counsel for the petitioner submits that the petitioner is seeking enforcement of the aforesaid order in the writ petition as a party in whose favor an order is passed has no remedy to is rendered remediless once an order is passed by the debt recovery tribunal. It is further submitted that debt recovery tribunal has no power to ensure compliance stroke execution of this order. Execution of the orders passed by
Except limited under section 19 of the Act, which do not apply in this case.
except under section 19 of the SURFACE Act, which has no application to the facts of the case. Paragraph in view of So why should you contest the prayer, Mr. in this petition?
I am not at all contesting, my lord.
Then you should say that, sir, we don't contest his prayer, we will put the property to auction.
Exactly, my lord, that's what happened. When I took the steps under section 14 of the SURFACE Act, it was noticed that the auction purchaser developed his property purchased by him by joining his other properties and made a 7-story building in that, where it was not possible for separation. Then, my lord, this court took notice and then, my lord, advised them to go for compromise. A compromise was reached and it was recorded.
So, you are asking something to do the impossible, right?
Not impossible. In a sense, my lord.
No. A plot was mortgaged, right? As we have plot was mortgaged, you have constructed 7-story. And then you will say that this plot belongs to this. In any case, the 7-story building is mine. The plot you have mortgaged, something like that.
This is what happened when this was reported by the auction purchaser that he revealed it, suggested a compromise. And when a compromise also took place.
Failed, no compromise.
According to my party.
No. So you had created a secured as you had mortgaged the plot in favor of the bank.
Plot with old structure.
Now on that plot, 7-story building has constructed by auction purchaser. Now that auction is cancelled.
Auction is cancelled.
So now you want this building to be demolished and again 7 floors to be just a minute. Like what flats? Maradu flats in Karnataka, Kerala, and then again direction to the bank to not auction your plot.
My only request is that when he has mortgaged, his property is not properly sold as per the DRT's order. What best this honorable court can do it, because since he is a remediless, his property has been sold for a song according to him, and it has rightly been set aside by the court. Please do justice. That's all I'm asking, Lord. I'm not asking for saying that demolish it about it. I only requested this honorable court in the meanwhile.
No.
Stay.
But supposing 1 minute. Supposing you would have been a counsel for bank, what would have been your submission in this writ petition? And supposing your client is supposing an auction, supposing if in person who intends to bid for this property, if the bank would put out by way of auction, what will you advise him?
I appeal for all the banks, almost.
No, what will you advise?
For all the banks, I represent.
What will you advise? We are asking.
They have been making representations without the word order is passed. The bank is in action. I'm advised saying that land would have been motion basis. Motion basis.
Yes,
May I request your lordship? One request, ma'am. May I request your lordship?
All right.
See the order dated 25/4/2023.
Yes. So he says he is rendered remediless. What is your submission?
My submission, your lordship, may kindly look.
You don't want to argue. He has opposed the prayer made by learned counsel, senior counsel for the petitioner. A case for prima facie, a case for admission is made out. Petition is admitted for hearing. We are not doing anything. Admitted for hearing. Yes.
Last occasion, the learned common pleader sought time for filing a counter.
Not filed, my request 2 weeks, item 22.
Admitted for hearing. 4 weeks time to file counter.
Obliged. They both go together.
Both go to 22 and 23.
21 and
21 and 22 go together.
22 and 23.
21 and 23, I'm sorry.
22, 23. Yes.
Obliged.
Yes.
2 weeks time. I'm getting first and second respondent.
Petition is admitted for hearing. Praise for 4 weeks time to file counter.
I beg to represent Dominic Fernandez, my lord. Your lordship may kindly grant this 2 weeks for filing counter.
Petition is admitted for hearing. That counter, if any, on behalf of respondents, we filed within 4 weeks.
Obliged, ma'am.
Concerning the multi-level parking issue,
My lordship, I am the petitioner, if I might be permitted. I filed this present petition, my lord, seeking that a multi-level car parking may be constructed for the purpose of advocates' car parking. My Lordship, the relevant part of this case is the order passed by this Honorable Court, which has been wantonly disobeyed by the respondents. My Lord, as such, today on record, we have only two respondents, the impleaded respondent number 2 and number 3, since the first respondent has so far not filed any memo of appearance as such. My Lordship, after numerous adjournments were taken by the respondents, this Honorable Court finally passed an order on the 4th of April directing the respondents to proceed with the demolition and construction of the multi-level car parking. My Lordship might see that the order, the operative portion of the order, my Lordship, is in...
There is no order 4th of April.
My Lordship, in IEA, order was passed in IEA, and as per the orders in page number 3 of said order, order dated 4th day of April 2023.
Where is 4th April? Oh. 4th, yes.
I would read the operative portion, my Lordship. In the second part of the order, second page of the order, the last second paragraph, first line, since the government has already granted sanction for demolition of the H block, the registry is directed to take immediate steps for demolition of the old building and keep the premises ready for commencement of construction of parking block. We direct the registrar management as well as the executive engineer R&B department to take immediate steps for calling the tenders, identifying the contractor, etc. The next para says, my Lord, in order to monitor the progress of the case, writ petition is kept pending. My Lord, this is the first and the last order passed by this Honorable Court in this present case. Subsequent to this order, my Lordship, peculiarly the first respondent passes another order, which is nothing but a contempt of this Honorable Court, dated 16/5/2023, on the 16th of May, 2023. I am Dr. Eunice, my Lordship.
Huh? Petitioner.
Yes, my Lord.
13%.
My Lordship.
You are appearing with bands on and all that.
All right, my Lord.
No, don't do it. Go outside.
Yes,
It's
my
not.
Lord. Yes.
Please go
I
outside.
seek leave of this court.
Please go to outside.
Yes.
Please go.
Yes.
And come back.
Muslim follows they don't take permission from the official. So the new
Yes, my Lord. Yes.
So it is filed through a council, right?
Yes, my
And
Lord.
you are appearing at the party in person is required to seek permission from
There is no such permission, my Lordship. If I might,
13% committee required to give permission to you.
if I am allowed to represent my Lordship, there is no such provision. There is no such provision, my Lordship.
I myself, in your own matter, I passed an order.
My Lordship, there have been several orders passed by this Honorable Court.
No, at least I am a party to a decision where I passed an order in your case, even in a 14% council filing, I have interpreted that GO and said it applies as a respondent.
My Lordship, if I might be allowed to make an action,
No allowed this thing.
the Supreme Court set it aside.
1
It
minute.
might be allowed to mention it. The
1
Supreme
minute.
Court has set
Please,
aside the order.
listen to us. You obtain permission from party in person. We hear you tomorrow, day after.
My
Yeah.
lordship, the Supreme Court has set aside the order.
Where is that order?
Yes, my lordship, it is available. I was not expecting that because I have not brought that order. In the
Now
case,
you produce. Mr. Write her name appeared as a counsel. However, from perusal of the first title, we find that the
petition. I withdraw the petition, my lordship.
we are asking you to obtain this thing.
My lord, I refuse withdrawal of the petition. I may be permitted to withdraw the petition.
This is what public interest it is.
No, my lordship, it is the writ petition filed in by myself. I withdraw it. Let the matter in my lordship.
After arguing the matter to some extent. No, but you are party in person.
I'm seeking
party-
to withdraw
for
my
party
lordship
person-
back thence.
13% seeks leave of this court to withdraw the writ petition.
Yes.
Accordingly, the petition is dismissed as withdrawn. Yes. Next. Now this is 33B.
Withdrawn.
No, this.
Lordship may take up this matter for 30 minutes.
You have challenged the validity of the rule.
Challenge the validity of the rule.
We told you to do so by way of an amendment.
Yes, my lord. I have filed the amendment petition. Morning, I made a mention, my lord.
So
230, your lord.
3B. You are challenging, right? Rule 3.3.
No, my lord. I am not challenging the rule. As per the rule, I am entitled to. My lord, I am not challenging the rule, my lord. That has been my.
Madam, please don't, harm the interest of your client by not challenging. That's the only request we can make. The other petitions have been heard by us challenging the validity. Yesterday, we gave you that Saturday, Friday, we gave you opportunity to challenge the rule. You know that in case we hold that you are don't covered, then you go out. Otherwise, all others who have challenged the validity may get relief. We don't know. Don't cause harm to this young person by your adamant attitude that I will not challenge.
I am not saying I will not, my lord. My case is
This
not.
poor person will suffer because of your ignorance. My lord told you that day to file an application for amendment.
Yes, my lord. As per the rule.
We expected that you will file an application challenging the rule. You are not doing it and still saying that I will not challenge.
My lord, your lordship may
We
kindly
can't-
take it up at 2:30. my lord. The petition, amendment petition is also.
Where is the amendment petition, madam? We don't have time. We have said no, that it be called. Where is it? It's not come. Why?
My lord, I filed it on Friday, my lord. That was returned. I'm having
Copy.
one copy, my lord.
Give copy. We can't, it's not a luxury litigation, madam, that this thing. You don't understand what to do. You have challenged the rule, not challenged.
My lord, your lordship may kindly adjourn it to tomorrow, my lord. I will also file that petition, my lord. I am not.
Learned counsel for the petitioner once again prays for adjournment in order to enable him
Tomorrow,
to
my lord,
make
because council.
an application for amendment. List tomorrow. Don't play with the lives of young people, madam, on account of your ignorance. That's the only request with folded hands we can make. Whatever he or she has complete trust in you. Don't what happens if a surgeon commits a mistake and leaves Caesar in your stomach and forgets to take out. That's what you're doing. Don't do it. Challenge the rule.
Yes.
My lordship, your lordship may take up this matter 2:30, my lord.
29.
This matter, also,
The state is saying that neither local marks are non-local.
What? Yes, Mr.
no, this may be passed over, my lord, 2:30.
Actually, what 2:30? You have to file counter, right?
They said this is.
Your lordship may take,
Instruction.
your lordship may take up my matter. After tomorrow, my lord, we have sent the counter for signatures, my lord. So, your lordship
Where
may
is
take up.
Mr. Rao? Where is Mr. Rao?
Next matter is coming. Lordship may kindly pass on, my lord, because.
Pass it.
Counter? You have to.
Counters for 5 matters.
All right.
The lands which were allotted, they are not free of cost. They are subject to the regular alienation proceedings, my lord. That subject to lordship's.
So this, it has to be heard, Mr.
It has to
Advocate.
be heard, my lord, but the interim order goes to show that, my lord, it was free of cost, but it was not the free of cost at all.
All
My
right.
lords, subject to lordship's kind permission, my lords, if the regular alienation proceedings, my lord, whatever rate the government fixes, if that is allowed to be, my lords, by the government, that report will be filed before your lordships, but what cost that can be considered for allotment. That's what I seek for, my lords.
Correct?
Yes, my lord.
That's fair proposition.
It's a fair proposal, my lord. We do agree.
So what do you submit, Mr.
My lords,
You want time to file?
my lords, the government will be allowed to, my lords, follow the procedure in the matter of allotment at a price as per GOMS 571. Well, that report I will be placing before
571.
571, GOMS 571.
Correct, madam. 571 of which year?
49, 2012.
GOMS, yeah, yes, ma'am.
49.
No, not. He is making a statement, madam.
Yes.
This is a public interest litigation, right? The land will not be, it neither belongs to you nor it will be allotted to you. It's a public property. It should be allotted in a manner which is in consonance with Article 14.
Yes.
Learned Advocate General has said that they may be permitted to adopt a procedure for allotment of a land in accordance with GOMS 571 dated 14/9/2012. And he says that the land will be alienated at the market value.
Yes, my lords. And I'll place
We don't see any reason not to accept this reasonable prayer. That's what he is. Madam, the problem is that we hear him with a free mind. You don't hear that, you feel that Advocate General is the enemy. So what he says is always incorrect. You listen to him. This otherwise, he also knows the law. Everybody knows law. Correct. So we will modify this order.
My lords.
I apologize to interfere, my lord.
1 minute. Your case 84.
84, my lord, IA number 2, my lord.
These people who are.
I filed impediment
One of the
petition.
allottees, my lord, respondent.
That's why you are saying, we thought that how can petitioner counsel be so fair? That's why you are saying, madam. So are you petitioner in 84 of 21? You are 84. Then he is also saying I am
I filed
petitioner.
impediment petition, my lord, IA number 2 of 2021.
No, nothing implicit. This is,
Sir, the land belongs to me. That is my claim, my lord. I have
you
filed.
fight it out in civil court with the government.
I filed, my lord.
Please appreciate, in a public interest litigation, two constitution bench, in a writ petition, in fact, or a public interest litigation, two constitution bench of Supreme Courts have held, to which we have recently referred, that question of title cannot be decided. So by impleading you, we cannot say that you are the, we will not record evidence here, your deposition, their deposition, will not permit you to file a plaint. Then if they will file WS, then your evidence will be recorded, issues will be framed, cross-examination, and then argument, and then we will not hold that you are the owner. If you are the owner, take recourse to such remedy as may be available to you in law. This is public interest litigation. Her grievances, public property cannot be sold for a song. It must be this thing allotted in consonance with principles of law. Right, Article 14.
So I approached this honorable court, my lord.
Then
Entry
you
was
approach
allowed.
somewhere else. We don't know whether this
No, let there be an
district court is an adjoining building here. Where is district court? Here, this side.
This is the
This side.
This side.
Yes,
So go, what is that direction?
So city civil court, my lord, towards one of the eastern side.
No, eastern side. So go eastern side. It's a very auspicious direction. Go. You understand, right?
My lord, let there be an
Yes,
observation that I only
you
submitted.
will observe,
I
definitely.
approached this honorable court, there was an entry order granted. Not
We
the-
don't know. This question of Mr. Give that madam two judgments. Every time you read the judgments, just now, last week,
Let
we
there
have,
be that observation, my lord, is only my
One minute.
submission.
last week we have delivered the judgment. Please take the trouble of going through it. Thursday we have delivered the judgment, running it to more than 50 pages. That constitution, in a writ petition, question of title cannot be gone into. We are bound by this. Anybody else may not feel bound, but we are bound by our own judgment. Both of us are party. I am the author. So therefore, I cannot, don't expect me to take a contra view in your case and to declare title in a writ petition by way of impleading that he is the owner of the property in question. So you want a modification, right, madam?
The same order may be called.
But you agreed, madam. There is nothing to.
So that the report will be placed before this court for consideration.
They will have a right to challenge. This is the G one, which a policy has been framed.
Let him, madam, pass an order in this thing, GO 14/9/2012 dated. In case any order is passed in contravention of GO, you will have always liberty to challenge that order. Don't say yes. This is, Mr. Please. No, madam, please understand. No. One thing you please appreciate, by making such a statement, Advocate General has virtually conceded that it can't be done. Right? You are succeeding. There after his statement, we will examine in this public interest litigation whether the land has been alienated in accordance with this GO number 1. And if it is so, not so, then still we can interfere with that action.
Yes.
Right? So which is the order you want modification?
My lord's order dated, my lord's 28th June 23.
28th June. Yes. Mark the press.
Stopping construction sites.
One minute.
Stay has been granted, my lord. Stay of the.
Yes. GOMS. Mark the presence, everybody's presence. This public interest, in this public interest litigation, the petition. But we are continuing that order. Full stop. In view of we have perused GOMS 571 dated 14/9/2022, 14/9/2012, full stop. The aforesaid GOMS prescribes the procedure for allotment of the land at market value. Therefore, a full stop, after hearing learned counsel for the parties, we permit the state government to assess the market value of the land in question in accordance with GOMS 571 dated 14/9/2012.
Yes.
Full stop. It is, however, directed that no construction, that the construction, if any, made by respondents 4 and 5 shall be subject to result of the writ petition, and no further construction shall be made by respondents 4 and 5. Line below, to the aforesaid extent, the order dated 28/6/2023 passed by division bench of this court is modified. However, the state government is further directed to produce the proceeding with regard to determination of the market value before this court, after supplying a copy of the same to learned counsel for the petitioner.
Yes.
Paragraph. Accordingly modified. In the result, IA 2 of 23 and 3 of 23 are disposed of. Then before that, everything, madam, you write first in the heard on IA so and so, this public interest litigation. Before that also, you write I heard on IA number 2 of 2022. 21. So 2 of 21. Learned counsel for the implete petitioner submit that the petitioner is the owner of the land measuring 10 acres which has been allotted to respondent number 4 and 5, and the government has no authority to allot the aforesaid land to respondents 4 and 5. On the other hand, learned advocate general asserted that the land in question belongs to the state government. Paragraph. The constitution benches of Supreme Court in so and so versus so and so PLN. Take. In so and so and so have held that the question of title cannot be gone into in a writ petition. Full stop. Therefore, this IA 1 of 21 is disposed of with the liberty to implete petitioner to establish his title in accordance with law before an appropriate forum. With the aforesaid liberty, IA 1 of 21 is disposed of. Then you write heard on IA number 2 of 23 and 3 of 23. Then hold this public interest litigation and all that.
I'm mobilized.
Yes. 31 and 32. No, not at the, whenever he files, you get, otherwise, see, we give a date on that day, he will say, I want 2 weeks time. What's the fun? So you can mention any time, madam, when you receive.
Deeply obliged. Appearing for the petition.
I appear for item number 31 and 32 for
FTL level.
respondents.
So
For respondents, I appear, madam. My lords, I request for a short adjournment for tomorrow.
you have been, that's the prayer that repeatedly, that's the opposition that repeatedly you are seeking adjournment in this case.
Last chance by given, my
And
lords.
guilty of encroaching FTL and violating the order for which contempt should be committed. Contempt.
Yes, my lords. The concerned council is
You
on
have
his
late-
legs before third. My lord, arguing the matter, my lord. For that reason, I request a short
No,
pass
which-
for tomorrow, my lords.
This is Court Hall 1, right?
Yes.
Who should get precedence?
My lords,
You tell us.
short pass for my lords.
Who should get precedence?
My lords.
Your
What do you say?
Lordship is, that is held up in other court, he is saying. Tomorrow or day after tomorrow.
Tomorrow, my lord.
Not tomorrow. Tomorrow it can't come. Day after, 30th August. So and so prays for adjournment and assures this court that he shall not seek any further adjournment.
Obliged.
List on
Yes, my lords.
30th August 20.
Obliged.
May it please your lordships.
Mister, have you filed an affidavit?
Yes, my lord, I have
Claiming
filed the
delay of 5 years?
on 2 grounds, my lord. One is that, my lord, the GO was not uploaded in the website.
No. First is you did not know. Second ground is you did not know.
No.
Arey, Mr. Prabhakar, at least you should be able to smile, right? You so everybody is so serious, right? Huh? Yeah. So
My face,
yeah.
smiling face, my lord.
Party did not know Prabhakar.
No, the brother has put it in a very better way than what I. First ground is party did not know about this geo, MS, whatever. And second ground is he did not know Mr. Prabhakar.
Lordships, at page 3 and 4, I have categorically stated that, my lord, when the GO was uploaded in the website, immediately I have made the representation before the authorities. And for the same, my lord, GOs were not uploaded for the several years, my lord. For that, my lord, one person has been filed the public interest litigation before this honorable court. Then order was passed directing them to upload. Then they were uploaded. Then I have already been made the representation, my lord, on 15/12/2022 at page 45 to 50, my lord.
15, no, what happened, Mr. This GOMS was issued on 5/9/18, right?
Yes, yes.
And then when it was uploaded?
Uploaded, my lord, in the year 2022, they were uploaded, my lord.
Date. Again,
Date has
same
not been
thing,
mentioned,
second item, same thing was, he said.
After passing an order in PIL, my lord, they were uploaded.
When?
Yes. Your lordship's order is there, my lord. I have,
22 uploaded.
yes, in the year 2020.
Then when did you know?
Yes, I came to know that, my lord, 13/14, immediately 15/12/2022, I made the representation.
15/12?
2022.
Representation.
Yes, my lord. To
You
set
learned
aside
about
the same.
it in December 22.
Yes.
And then when was this petition filed?
Petition is filed, my lord, your lordships, on 17/6/2023, after 6 months, my lord.
All right, correct.
And
all right.
And earlier division bench of this honorable court directed me to get what was the positions of the land. For the same also I brought photographs, my lord, plain land was there.
In compliance of the order dated 15/6/2023, learned counsel for the petitioner has filed a better affidavit. Paragraph. The Prasad, Advocate General just now has made a submission in another case. You better speak to him. We are learned counsel. Learned counsel for the petitioner submits that the order of allotment was passed on 5/9 to white GOMS dated 5/9/2018. However, the same was uploaded in the website of the state government only in the year 2020-22. It is further submitted that the petitioner came to know about the aforesaid GOMS on 15/12/2022. Thereafter, the petitioner submitted a representation on 15/12/2022 and filed a writ petition on 17/6/2023. In view of aforesaid submission, petition is admitted for hearing. Issue notice.
So I may be permitted to take out personal notice to the sixth respondent, my lord.
Personal notice and personal notice to R6, whatever.
I'm deeply
Proof
oppressed.
of service.
Deeply oppressed.
Your lordship's kind leave, I beg to represent Mr. Satyanarayana Rao. This is a matter with regard to public service commissions. Your lordship.
What happened?
Your lordship.
Those people had filed a chart, right?
What your lordship was imagined on that day came true now today. Your lordship made very clear, sort on page 5 dated.
No, what affidavit?
Now they come forward with a counter affidavit
Now stating. My lordship.
Where is the affidavit, madam?
Filing of.
What happened? You have failed.
No, they have revised other person's marks and increased it after your lordship's orders. That was not what your lordship was stated. In order to.
No, Mr. You, petitioner has secured above cutoff marks.
Yes.
Huh? 1 minute. Petitioner secured above cutoff marks.
My lord, as per the revised the entire candidates who have been appeared for the examination.
But this is
Have
what
been
it is.
revised, my lord.
188.
Immediately, see,
191.5. So by virtue of applying the same revised scale, they now go up saying that even others marks have
no, so cutoff is how much?
cutoff is.
What is the cutoff, revised cutoff?
198.
That they are maintaining the cap.
198 is the revised cutoff marks. Whereas the petitioner has secured
May I request,
This will have to be heard then, right?
only one request, my lord, if your lordship permits me. 1 second.
No, you take instructions on this, file something, otherwise, see, they have filed an affidavit stating that revised cutoff is 198, 1 minute, as we have understood. As per their affidavit, revised cutoff is 198. You have got 193.5, so still below cutoff. You will have to do something.
I filed a rejoinder to that, that 198 is never there. When did they do it? Nobody says. Doesn't say so in the reply affidavit.
No.
Even on that day also it was not there.
No, Mr. Lakshmana, as I understand their statement is, by virtue of applying this revision, whereby you have gone from 188 to 193, they applied the same revision to others. That is how they went to 198.
In the counter, so my lord.
That is their case. Otherwise, why will it increase?
Your lordships may kindly see the counter affidavit. Simply they said 198. When have they done that? That is after your lordship passed an order.
Yes, in compliance, we will admit, in compliance of the order dated 31/7/2020-23, Secretary of AP Public Service Commission has filed an affidavit wherein it has been stated that the revised cutoff marks are 198, whereas the petitioner has secured 193.5 marks. Full stop. Learned counsel for the petitioner has disputed the aforesaid submission by filing a reply. The petition is admitted for hearing. Admitted for hearing. Yes.
May I make one humble request, my lord?
We will hear it sometime, Mister. It's admitted right now. Now they will have to substantiate what is the revised cutoff mark. That every this thing, right? Substantiate it by producing record that revised cutoff mark not only for petitioner but for everybody.
May I request?
Mister, if it is so, then you don't have a case. If it is revised cutoff marks has been or for all, yes. Learned disputed the same. Learned counsel for AP Public Service petition is admitted for hearing. Counsel for AP Public Service Commission shall produce the record.
October, November, 2014, October, November date, please.
You can file a memo after he is ready with the record. We give memo in the morning, right, Mister?
Meanwhile, they can file, like how your lordship was said, in the meanwhile, they can file it, please.
No, but this is not the only case. Other cases.
Some.
Now ask him not to be dependent on the litigation of the court. You know how fortuitous it is. So he should do something else also.
Very difficult. October, November, meet.
Make an application. We will give a date, Mister. What said that?
Lordships kindly, Lordship kindly grant 1 week time, my lord, because except one and
lack of government.
Except 1 and 6, my lord, all other respondents filed counter. Lordship kindly grant 1 week, my lord.
Admitted for hearing, learned counsel for respondents. Admitted for hearing, learned counsel for respondent 1 to 6. Praise fund is granted 4 weeks time by way of indulgence to file him or to enable them to file a comprehensive affidavit indicating the facilities available in a government hospital. Yes.
Item 36, letter GP for general administration, GP for revenue.
Want to file. In this millet, I filed the impleading petition millet, Eidgah Dargah and Graveyard Committee millet. And I want to come on record millet.
Why?
Millet, this land millet, subject part of the subject land millet, since last more than 200 years in the position of.
The response 4 and 6 millet counter has been filed.
No, so you and no remaining respondents don't want to file counter. You have filed.
In the
no, Mr. Don't say who has filed. We are concerned with who wants to file. Otherwise, we will say that none of respondents, the remaining filed, want to file, right? Who are you? What do you say with regard to his application?
Millet,
you are the owner of the land.
Not owner millet, the Eidgah Dargah Committee millet. And since last more than 200 years, millet, that is in our position. Dargah is there, Eidgah is there.
No, but are you the owner of the land?
No, not owner, but permissions are also granted by this municipality millet for construction.
We understand, Mr. But what is your case? You are not the owner, but in possession for 200 years.
200 years.
It's a government land. That's what.
Exactly.
That's what we are asking.
Yes, exactly.
To ascertain whether you are. What do you say?
Yes, but I've stated.
He is an occupant of a government land. He should be heard, right?
Yes, it's not the government land. Land belongs to the committee, Waqf committee, my lord.
He is saying that it belongs to you. What are this thing, right? Perhaps in a complete petition, you should have exchanged the title when somebody was appearing.
It was with the permission, not even funds have been sanctioned for the construction of the compound wall by the
petition is admitted for hearing.
Hold
on.
One more submission, millet. Same relief, millet, WP 1640 and 23 is being filed.
1 minute. Heard on IA number 1 of 23 for the reasons assigned in the application duly. So, after hearing learned counsel for the parties and in view of the stand, delete earlier one. In view of the stand taken by the learned GP, it appears that proposed respondent number 7 is a proper party to the list. Accordingly, IA so and so is allowed. Registry is directed to implead so and so as respondent number 7. You want time to file counter?
Yes.
So, learned counsel for 1 minute.
In my affidavit, I generated millet for the answer.
Don't want to file counter, right?
No, I have additionally. I narrated all facts millet in my affidavit, but if required,
that affidavit is gone, right? IA is allowed.
Then I file my counter.
Learned counsel for respond number 7, President is granted 4 weeks time to enable him to file counter. Let counter, if any, on behalf of respondents, remaining respondents who have not filed counter, be also filed within 4 weeks. List for another as jointly prayed by learned counsel for the parties. List along with WP pill number. That is before single judge, right?
Yes.
File an application for delete, madam. File an application for linking. You cannot get away by this. Yes. Ragging.
Counters are filed on behalf of all the respondents.
What have you done?
Yes.
See, Mr. Is it your case that you have been... Sit down, madam. So, is it your case that you have been following the guidelines laid down by Supreme Court in Vishwa Jagriti Mission?
Yes, ma'am. Yes, ma'am.
What is Vishwa Jagriti Mission?
Sorry, my lord.
You don't know, Mr. And you are saying yes.
I'm sorry, my lord.
Vishwa Jagriti Mission is the judgment of Honorable Supreme Court where they have laid down the guidelines. Yes, Madam Perus, heard on the question of admission. In this, this petition was registered on the basis of communication addressed to this court in which the grievance, in which the issue with regard to ragging of the students, students in the colleges in the state of Telangana has been raised. Paragraph. The respondents have filed the counter. Paragraph. We have heard learned additional government whatever GP for revenue to some extent. Honorable line below, Honorable Supreme Court in Vishwa Jagrati Mission versus Central Government 2001 bracket close 6 SCC 577 has laid down the guidelines to be followed by the authorities. The guidelines are reproduced for the facility of reference court para 7 to 22, right, madam? The GP for revenue. Mister, what action have you taken to against that delinquent? This case has resulted in a death of a student, medical student.
Yes.
What action?
In fact, that's.
Have you lodged FIR?
Yes. FIR.
Yes, madam.
Been filed, my lord. And he was
The
suspended on.
GP, health, revenue, whatever, shall also state on affidavit, shall also apprise this court with regard to the action taken against the delinquents which resulted in death of a first year medical student, PG medical student on account of ragging.
I'm representing respondent number 4, Commissioner of Police, my lord.
Whatever, we don't know.
Counter, and we have
So
filed,
he and Commissioner Police.
we have filed a counter.
No counter, we are asking Mr.
The report.
What action have you taken? You shall file an affidavit. What is the stage? Only FIR registered, nothing
We have
doing.
filed charge. Accused were
Relaxing in the police station.
We have
You
filed
understand?
charge.
You understand what action has been taken from registration of FIR till the date of filing of affidavit.
Yes.
Don't say I have filed counter.
No, we have filed charge sheet and
The
accused were
moment-
arrested.
Maybe
Even they
moment
jailed.
we will open your counter, you will land in trouble. So better do it. What we are asking you to do. This is a serious issue, mister. 38 is done. 38 you have given, not called. 38.
Wait, please, your lordship.
Counter.
But first respondent former party, second respondent.
Nobody is filing counter. What to do? Your petition is allowed. What is the prayer?
Your lordship, the petition is prayed challenging anomalous in pay fixation of the petitioner, your lordship, on his
All right,
petition.
petition is admitted for hearing.
No issue, your lordship.
Let this petition 39, madam, let this petition be listed before a bench in which one of us write his lordship's name is not a member.
Submission, my lords, transfer petitions were filed before the Honorable Supreme Court. This matter has been transferred, my lords.
Transferred, all right, delete. Which is the order, madam?
My lords, pass it.
Transferred where?
Transferred to the Honorable Supreme Court, my lords.
All right, the learned, madam, yes, 39, right. Learned counsel for the petitioner submits Correct.
Much better.
I think you went in favor of the chartered accountant. Cap is 45 tax audit was that was checked. So Madras High Court held in favor of chartered accountant. DG confirmed with them. So they might carry the matter to Supreme. Similarly, other states also they filed as challenge over there. So we know the Supreme Court not granted.
Yes.
I can what if there was people prohibition in HC.
Nobody is
Coming for affidavit of respondent.
admitted for hearing 4 weeks time. Granted to file counter.
This time for all the respondents, my lord, I seek 1 week time, my lord. I'm ready with the counter, but I have to make some corrections, my lord, 1 week time.
4 weeks. But the purpose of 4 weeks is to ensure that you grant, right? You file the counter, not 1 week you will say again it will come after 1 week, again you will say 2 weeks, 1 week. So that's why we are saying 4 weeks. Don't take that after 4 weeks again you will ask 4 weeks. Correct. Yes. No, pass over, madam. No, no, acha. Pass over. This is final hearing. Why? No, we'll call. Oh, what they have been told, madam, to come at 2:30.
The implied is 230.
2:30. All right, then 42. But we change this. We change that as soon as motion hearing is over, pass over cases will be called. Again, see what happens that we start hearing final hearing matter. Then motion go to other subject. Why?
Tomorrow onwards in the list,
Not that.
parcel of matters will be taken up immediately
After we go over. Note. Get in the note.
May it please your lordships. The petition is arising under Urban Land Living Act.
The respondent, petitioner.
I'm passing on a short note for your lordships perusal.
Yes.
Yes. The learned single judge's order is at page 19, my lord.
Page 19.
My lord, I have passed on a short note, my lord, wherein, my lord, my first submission is the Atia Muhammadi Begum's case was decided by the learned Supreme Court, my lord, in 1993. And this was overruled by the Supreme Court, my lord, by the, in the case of State of AP versus N. Adikeshava, which has come in the year 2002, my lord.
Citation, madam. Citation.
I will just.
Page 5, your lords.
2002, one Supreme.
AAR 2002, page 5.
And Atia Mohammadi,
Yes, my lord. Atia Mohammadi Begum's case.
93.
1993, volume 2 SCC
546.
546.
546 is the page.
Yes.
That's my first submission, my lord. And when the judgment was passed, my lord, in the year 2001, the Honorable Court has relied on Atia Mohammadi's case, my lord. Then thereafter, my lord, the writ appeal has been filed because the writ petition has not attained the finality. Atia Mohammadi case was overruled by Supreme Court, my lord, in 2002.
Give us, madam, 5 minutes.
Yes, ma'am.
Because what you have done is you have not stated facts. So we will have to write facts also. We will read it. Give us 5 minutes.
Let it see on this number 391.
Correct.
No. That's open that.
Yes, madam.
My lord, as on the date when the act was commenced, my lord, Balapur was not covered under the ULC Act, my lord. Balapur.
17 to 1976.
Yes, my lord. As on the commencement of the act, Balapur village was not covered, my lord, under the ULC in Schedule 1. Thereafter, my lord, by way of extended master plan, my lord, this village was added.
When?
On 23/6/1980, my lord, by way of GOMS number 391.
What is GOMS master plan?
Yes, your lordships.
Sir, development plan you
Development of the.
plan.
Yes, my lord.
Development plan you call.
Development plan.
So with reference to development plan, you are trying to say that the land on 17 to 1976 was a vacant land within the meaning of the ULC Act.
Yes, your lord.
Is it permissible in law?
That's what, my lord. As per Athiya Mohammadi's case, it is not. So, my lord, the
Not permissible.
writ petition was allowed. My lord, in 2001. Thereafter, my lord, the Athiya Mohammadi was overruled in 2003. We have preferred an appeal. My humble submission is, my lord, that.
No. So what does, because we have not dealt with this act for a long time.
Very well.
So
yes,
in this thing, 2002 Supreme Court, they said that it is permissible with reference to determine the vacant land with reference to a subsequent master plan.
Yes, your lordships. Even though the master plan has come subsequently, that has to be taken into consideration is what has been laid down, my lord, in Adi Keshava.
So you are relying on this 2002 judgment.
I am relying on Adi Keshava.
That's it. That's it. And you say that he should have filed an appeal.
True, my lord.
These two submissions.
Under the statute, my lord, there is an appeal by way of section 33. I am not for a minute saying, my lord, the alternate remedy under 226 cannot be invoked.
We know.
But when statute is available, my lord,
yes,
statute has to be. That's all.
Appeal under section 33.
33 of the ULC Act.
Oh, yeah, I heard it after a long time. 33 ULC Act.
Repealed act, correct? That is.
Repealed now.
Yes.
That was repealed.
Yes.
And then the litigation went on whether possession not taken or not.
Hariram case came.
Yeah, and you must have argued, we are sure, several cases before. You must have argued several cases. Possession has not been taken.
Argued more number of cases.
Panchanama, no. Mr. Rao is an expert, but you also must have argued.
Yes, yes.
Mr. Rao, I know, he told us that I only deal in land, nothing else. Yes. So, yes, Mr. Now what? So that's the submission, madam.
One more submission, my lord. Having submitted to the authority before the government, my lord, now he cannot take a U-turn to say
without jurisdiction.
Yes.
That's on 3 points quick submission.
Well, at the Urban Land Ceiling Act Master Plan originally came into force on 17 February 1976. Only 2 dates for it. 17 February 1976. The subject land, this Balapur, was not part of the urban agglomeration area in the master plan as on the date 17 February 1976. The writ petitioner no doubt filed a ULC declaration in 1976, but it was not necessary under the provisions of the statute. Then it went on for computation. Then after that, the Supreme Court in this Athiya Mohammadi Begum's case, 1993 2SCC 546 has laid down.
Mohammadi and 2003 judgment, where is the copy? You should give madam photocopies. Yes. So
it has laid down, that the act will be applicable only in respect of the original master plan and not in respect of the extended master plan. Here the date of extended master plan.
So what? There was a master plan existing on 17 to 76.
The master plan which came along with the statute was on 17 February 1976.
There was a master plan.
Yes.
In that master plan, your village was not there.
Balapur is not included in an admitted position. And there was an extended master plan or a revised master plan on 29th of September 1980.
29 September.
29 September 1980. As per the law laid down in Atiya Muhammadi Begum's case, the determination of the urban land ceiling would be with reference to the date on which the original act came into force. That was the legal position obtaining till this second case, that is Adikesh Reddy's case, reported in AIR 2002 SC page 5, was delivered by the Supreme Court on 6/11/2001. This date 6/11/2001, my lord, is very relevant because the judgment under appeal of the learned single judge is dated 6th August 2001. Before Adikesh Reddy's case came.
All right.
It was decided as per the law that was in force as laid down by the Supreme Court as per Atiya Muhammadi Begum's case. Appeal is filed after 4 years delay in 2005. And now they say that, and another thing, in the Adikesh Reddy's.
So why this 2002 judgment can't be made applicable to your case?
2002 judgment, Ballot itself said that they are not overruling the law laid down in Atiya Muhammadi Begum's case. They said it was not correctly decided. The last paragraph says. Ballot, there is a distinction. And they have also said that if any declarant has filed.
No. So, any master plan subsequent to enforcement of the act can also be taken into
Can also be taken into consideration. With reference to that particular date, Ballot, the determination shall take place. Therefore,
if subsequent plan is taken into consideration, your language.
The computation must be based upon the subsequent date, not with reference to 17th February 1976. This position is resolved by a coordinate division bench of this court.
Particular piece of and not. It has to be with reference to 17th only.
On the date in the determination of not taken, subsequent event with the master plan that can be linked.
This, according to para 14.
Yes.
The judgment, if by the date of this judgment, if the master plan is revised, subsequently, on that date, if determination has taken place, that can be looked into.
That can be valid.
That would be valid.
That will 29/9/1980 should be. And this position, Malad, has been resolved by a coordinate division.
No. So what happens as per subsequent master plan, your land is not a vacant land. Still not a vacant.
No, my case is that it is agricultural land, but it is computed as a vacant land.
No. What we are asking your question is that if you have read para 14 of this decision, so if subsequent master plan is taken into account to determine whether your land will be a vacant land.
No, that is not decided in this present proceeding at all, because the determination, computation done by the special officer competent authority.
So they should determine.
No, it's in such cases, Malad, the division bench, coordinate division bench says the matter will have to be remanded to the special officer.
Yes.
For determination.
That's what we are saying. You didn't.
Now, that is the difficulty. This is the judgment, Malad. May I just pass on to your lordship, Malad? This
No, it means, but the rights are saved, right? Proceeding, etc. Everything is saved. We will have to this thing.
Now the computation will have to be done, Malad, with reference to the extended date.
So they will do it. Same view which is taken by division bench.
If that time I refer to your lordship, Malad, 2002, volume 2, ALD, page 253. 2002, volume 2, ALD, page 253.
So we will remand, Mr.
Yes,
remand the matter. Correct. You are succeeding, madam. See, senior counsel has been so fair.
My only one submission is, my lord, after the master plan came into effect, the computation started.
Right.
The ULC computation from 6 months.
Madam, in terms of para 14 of subsequent decision, we are remanding the matter. We don't know. Where is the scope of arguing the matter once again?
No, my lord, I don't mean, I'm not arguing, my lord, I'm only.
No, but
It's about the date. That's all. The computation was after 80.
After 18?
No, after.
18? What 18?
Second one.
1980. The 8183 was in the year 5290.
Array, madam, we will have to explain it to you. Read para 14 again. It's not the practice of this court that we should convince before passing an order, right? If it is, madam, if you feel like that this is order is against you, it is subject to SLP, correct? We are not sitting here to convince you before passing an order. If you don't, he has conceded.
Very well.
Your appeal is being virtually, it is being accepted due to change in law.
Very well.
You still want to argue, we can't help it. Yes, mark the presence, madam.
May I just pass on this judgment?
Please.
Number 27, Mallet,
All right.
where the division bench has remanded the matter.
Yes, yes, we will remand in same terms. Thank you, Mr. This intra-court appeal emanates from an order. Order sheet you write, madam. Order sheet separately write arguments heard, reserved for judgment and signed date and dated and dictated in separate sheets, right? So then now judgment.
Number 27, Mallet.
Yes. This intra-court appeal emanates from an order dated 6th of August 2021 passed by learned single judge by which the writ petition preferred by the respondents. 1 minute. Writ petition preferred by respondents. You are not a counsel in this case. We have not appointed you amicus curiae, and please don't like this is Mr. Rao. We respect your age.
Remand, because the act is repealed, there are no authorities under the act. So there is no need of, apart from that, there are other issues where Balapur is situated in the peripheral area.
Mr. You should resign. Mr. You should retire because your clients have engaged Mr. Rao. So you should.
The legal question I am bringing to your lordship.
Outside the court, he will be asking me, Mallet. Here he is arguing for speech.
Mr. If we pass such a case, you argue in your case, right? He is saying that it should be remanded in division bench.
Statement of this honorable court will be a precedent in other cases. That's my.
This is 2002. 2 ALD is also a precedent.
And as on today, your lordship may kindly consider.
Mr. What to do? He doesn't want your case to be decided.
That's what he says is, Mallet, that when once the act is repealed,
it can't be remanded.
Remand will not
That
be
you are not arguing.
purposeful.
That you are not arguing. Fortunately for us. Repeal act is where, madam, give repeal act, please. Senior counsel, give a repeal act.
27/3/2018.
We will meet it also. Unnecessarily, half-heartedly, you are getting the case decided against you. Now we will deal with this issue also.
That is not my contention.
Not contention, but we will decide it also. That under repeal act, this can be remanded. Not your contention. We will not, he will, why to complicate, Mr. Your matter by resorting to submissions, right? Why to complicate, we will say. This intra-court appeal, please don't interrupt now. Don't interrupt. Nobody, please sit down, Mr. Senior Counsel. Please relax. This intra-court appeal emanates from an order dated so and so, dated 6th of August 2021, passed by learned single judge, by which writ petition preferred by respondents has been allowed. Writ petition preferred by the petitioners. Petitioners have been allowed. Full stop. In this order, the party shall be referred to as per their rankings before the learned single judge. Paragraph. Facts. Paragraph. The relevant facts. Continuation, right? The relevant facts which are necessary for adjudication of the controversy involved in this appeal may be set out, may be mentioned, which are stated here in INFRA. Full stop. Paragraph. The petitioners are agriculturists and are owners of agricultural lands. How much land? Agricultural land measuring 4 acre and 4 acre and 12 guntas situate at village Balapur, which falls within the peripheral area of Hyderabad agglomeration. Full stop. The provisions of Urban Land Ceiling Regulation Act, herein after referred to as ULC Act 1976. ULC Act 1976 came into force on 17 to 1976. Full stop. It is not in dispute that on the aforesaid date there was no master plan. The master para 27 and 28. No. Somewhat, no, division bench of this court also, in similar circumstances, comma, set aside the order passed by the competent authority and remitted the matter to the competent authority to determine the nature of vacant land with regard to with reference to revised master plan paragraph. In the instant case, comma, the master plan paragraph. No, in the instant case, the master plan which was in existence on the date of commencement of the act, that is 17/2/1976, has been revised on 29/9/1980. Full stop. The lands held by the nature of lands held by the petitioner has to be determined with reference to the revised master plan. Full stop. Therefore, the matter is remitted to the competent authority to determine the nature of land with reference to nature of land with reference to the nature of land with reference to the revised master plan. Full stop. Paragraph to the aforesaid extent master plan. Full stop. The competent authority, Madam, how much time limit? The competent authority shall determine. Otherwise, they will be shall determine the nature of the vacant land, nature of the land held by the petitioners with reference to its use in the revised master plan within a period of 4 months.
Yes.
4 months from today. Full stop. It is made clear that this court has not expressed any opinion with regard to nature of the land, as the same has to be determined by the competent authority. Full stop. You say that competent authority will be appointed. Is it functioning?
My lord, the special officer now has been given to the district collectors, all district collectors.
So it will be.
After the disbandment.
Learned counsel.
After the disbandment of the.
No. Is he?
The district collectors are empowered.
Learned paragraph, the statement made by learned government at whatever GP that all proceedings to be made. It must, in order to attract court, must be pending on the date of this. Must be pending. Not pending. 18th March. Proceed. In this case, the competent authority passed an order. 85. So it will not pending. It will not appear. That's why it is this 4/1. This has come on 18th March. Pending. They will have it up to 10, except 11, 12, 13, 14. Except 11, 12, 13, I all would have of it. They are not spending. Will not include the rate of spending. Correct, Mr. So, what is your take on section 4 of the Repeal Act?
Repeal Act, because now after
the only thing is, in this case, why we have this thing? In this case, what has happened that on 99, when the Repeal Act came into force,
Repeal Act came
no proceeding was except writ petition was pending. So whether the expression, I think there is a Supreme Court judgment also.
4, all proceedings will abate, you will find. I cannot argue that a writ appeal will abate because it's a constitutional remedy.
No. And single judge's order is?
Single judge's order was in 2001. That is.
But they are not arguing that your writ petition abated. All right. They are not arguing. Yes, madam. No, at this stage, delete. At this stage, learned whatever makes a statement that collectors are
Yes, my lord. The district
Collectors are
collector.
the competent authority under the
After the ULC Act.
ULC Act, which has been repealed.
Yes.
Since then, in the since then, that is repealed since 18th March 1999 by Urban Land within bracket Sealing and Regulation bracket close Repeal Act 1999.
This is state.
One zero seven. No, don't do. Arey, Mr. Not for. This is 2003 volume 1 107. No.
No, that is Indian Oil Corporation's case.
Ah.
Read about alternative remedy.
Urban Sarai something. She has taken out.
I remember by numbers, not by names.
No, no. What is the number?
2003, volume 2, SSC, page 107.
She has taken out 2002.
2003,
Ah.
volume 2,
Volume 2,
SSC, page
107.
107, paragraph number
Yes.
7.
Yes. That's what I also remembered. I have read it. Hey, madam, you should ask.
Well, the name of the case is Harbans Lal.
Harbans Lal. Yes,
Indian Oil Corporation.
Indian Oil. So my memory partly is correct. Harbans Lal, I said. 2003, volume 2, SCC 107. Yeah, this is madam. Harbans Lal Sahania and another versus Indian Oil Corporation. Apart from Whirlpool, we have told you, this is the citation. And I think this has also been reiterated for the followed. Shabil Das followed. I think, yes. But it's enough for the present case. No, Mr. We are so happy to decide a 2005 rate appeal. You can't, I mean, you will share the joy with us of deciding a case of a litigant who is waiting since how many years, we don't know, 18 years.
First petitioner passed away, others.
Oh, see. Thank you. Sorry, that's.
With my lordship.
Madam.
With my lordship.
1:30. No adjournment.
We need adjournment.
No adjournment. You, 1 hour you have at your disposal, please prepare.
Senior government.
No, you are the senior. We are appointing you as senior counsel. Notification will follow for the purpose of this case. You are senior counsel. 2:30. Get going.
My difficulty is.
No difficult.
My lordship.
File you want?
My lordship.
File. Madam, give him the file. He will sit here and prepare the case. Skip the lunch. No. These cases are not listed. Sorry, these cases are not listed for adjournments. We are very sorry. You had, say, tell them.
3 days you had, clear 3 days. It is not that we have listed yesterday night at 8:30 and taking up today.
No, sorry.
Friday, Saturday, Sunday, this is a matter of 2005.
Please, Mr. Cooperate. No, please cooperate. Please. No, let him be. You are senior counsel. Both of you, the notification will be issued appointing you as senior counsel for this WA. No, you can tell your senior court did not agree, what can you do? You only have, Mr. You only can pray for adjournment, right? You have done that. Thereafter, you cannot take guarantee to your senior that in all cases, 110% I will seek an adjournment. Forget about it. If you, even if you people don't come at 2:30, it will be decided.
Arrest.
Note 30. Yes.
After for the response.
Okay, then. Next. Huh? Pending IS 4127 all disposed of. Additional affidavit.
It will be disposed of, Last Minister.
Huh?
Since a particular position, it will be disposed of, Last Minister.
Huh?
It will be disposed of in terms of direction.
We do not find any ground to interfere, right? Yes. Yes.
I think
This you take. No. What do we do? Yeah. Madam, next case, 46.
I appeal for the response
Yes,
1 to
madam.
4.
Yes, Miss.
I appeal for the response 1 to 4, Lord. Since the orders passed by the authorities below under the ROR Act.
Council is no more. Council is no more.
Notice has to go to the parties.
Mark none for the appellant, so and so for the GP for so and so. Learned counsel states that the arguing counsel, that it is Mr. GP for revenue submits that Mr. D. Ramlinga Swami, who represented the appellant has expired. In view the aforesaid line below, the aforesaid submission is placed on record. Issue court notice to appellant for office is directed to issue court notice to the appellant for his appearance before this court on 3 weeks. 3 weeks. What is the madam 3 weeks after? Meeting 18 September 23. List on said date.
Appearing on behalf of us.
No adjournment.
No, my lords, appellant died, my lords.
Today?
No, my lords. We got information that he died and
when?
We don't have.
When he died?
We don't have information.
In end of the matter.
Like
it has abated then.
Give us 2 weeks of time in order to get in there.
No, this is not listed for when called. Supposing if we could not have been called today, you would have said tomorrow.
No,
that just now I have learned that he has died. So then we will ask you, how are you appearing for a dead person? Who is giving you instructions from there?
Satyaraj Babu sir said.
Feel a bit.
These are agency lands. Agency lands are regulation 17. It should be registered. It's related with several surveys to survey granting production.
Kindly 2 weeks.
No. This is what you have been told by your senior.
We get in.
Old tactics, mister. Old tactics saying that, so I have received information. Then on that day, sorry sir, that information was not correct. He is alive. All this thing playing tricks with the court will land you in serious difficulty.
No.
You understand? Your license on our reference may be suspended by bar council. Do you understand this? So therefore, don't, Mr. get into this thing. And nobody used to come there in my court like seeking adjournment because they knew that we are very tough. My brother also doesn't grant adjournment and you know him very well. So why should you like that? What happens if he is alive? You will go to jail. Agree?
Yes, my lord.
No. We are asking you.
Yes.
We will find out. We have means to find out whether your client is alive. And supposing if it is found out that he is alive, we are only asking you what should we do. Tell us. Not if he is alive.
No, we got the information that he's
No. So what should you, we are relying on you and we will find out, supposing if he is alive. What should you do for making a false statement before the court? That's what simple thing we are asking. You are liable for contempt, correct? Huh?
Yes.
Correct or not?
Yes, ma'am.
We are not saying that you are not correct, but we are saying that in case it is not correct, the information, what should happen? That's why, Mr. Young man, you should be absolutely serious about the proceedings. But somebody in the corridor said, let's get an adjournment, he has died. You will land in trouble. Got it?
Sure.
We will recording your submission, adjourning it by 2 weeks. It has abated.
Sure, ma'am.
Huh?
Milords.
The appeal has abated because you have not brought his LRC in within time limit. The consequences, appeal abates.
We'll get the information and
No information. What to do?
And it needs a week's time to bring the advice and we come to pursue whether we are interested to pursue the appeal or not. So put it in next month.
So he is claiming on the basis of an registered salaried in respect of an agency. The title of the appellant appears to be based on an unregistered sale deed in respect of land in question, which pertain to an agency land, full stop. However, Mr.
Office of Satya Raj Babu.
No, your name.
Sailesh.
Huh?
Sailesh.
Mr. Shailesh, appearing for the appellant, submits that appellant has expired today.
No, my lords.
Huh?
He's no more.
3 days. I mean, you knew that you had Friday, Saturday, Sunday. You are waiting for
my
the case to be called.
My senior mentioned that he's no more, sir, my lord. So,
Mr. Please appreciate the senior will not go behind bars. You will go. Understand?
Sure.
Because he has not made a statement. You are making a statement. Correct. So, in view of aforesaid submission, let application for substitution, if any, be filed within a period of 1 week, failing which appropriate orders in this appeal, which may have abated, shall be passed. Nothing to smile. Supposing if you would have argued, then smiled, we would have appreciated. You understand there is nothing in the case. Get it? Have you read the file?
No, my lords.
We want to assure you that if you go through the file, you will not get neither conjunctivitis nor viral fever. Correct? That's an assurance from the court. So always read the file even if somebody has died.
Sure.
Because court may not believe your statement. Next Monday is what, madam? 4th September 20.
2 weeks.
Don't come, mister. You have not experienced that this court is tough court. Again, old tactics. Don't come. Your senior's case, not yours. If it doesn't move within 1 week, that means petitioners, LRs are not interested in prosecuting the appeal. Got it? Yes. Next, madam.
Yes.
Oh, Mr. Rao.
I am for the respondent writ petitioners, Your Lord.
Where is the appellant?
My lord, I am for the appellant.
Yes.
For in writ appeal 648,
Somebody has died.
we filed, my lord, LR petition. Formally, it may be.
All right.
And
Heard on IA 1 of 2023 an application seeking substitution of
Lots of appellant.
appellant for reasons assigned duly supported, allowed. Same is whole thing. Same is allowed. Let amendment be carried out in the cost title within a week. List on 4th of September 23. 4th September, Mr. Rao, Monday, next Monday.
It's the 4th September, I am not available. Your lords may have it 8th or 9th, your lords.
8/1.
My lord, in the next
One
update.
8th is Friday. We can have it on 6th if you. 11th September.
I leave to you.
11th September.
I leave to you.
Yes.
Much obliged.
Same is the way, my lord, in second.
Second also is the same.
There is one LR petition.
Second means 46.
46 also is the out of the same judgment writ appeal arise.
Writ appeal 1004.
You said 648 is LR.
There also, my lord.
Both right, madam, both cases. Yes.
Both may be posted on the same.
Yes, yes, same.
Much
date.
obliged.
11th September.
Your Lordship, I'm appearing item number 48, Your Lordship.
But
Lordship,
petitioner has died.
I am appearing in item number 48, writ petition. Petition,
So
Your
what,
Lordship.
petitioner has died? No.
Yes, Your Lordship, I am appearing on behalf of the petitioners, Your Lordship. May I request Your Lordship may taken up on Thursday, Your Lordship, as senior is unwell.
No, if he has died, out of the matter.
No, Your Lordship, matter pertaining to constitute the Board of Trustees, Lordship, till now, till now, they have not been constituted Board of Trustees.
Trustee, hereditary trustee, hereditary family trustee, madam.
No, non-hereditary.
Non-hereditary. They do not have non-hereditary trustee, they do not have any right of hospital.
How does a non-hereditary trustee have a right?
Your Lordship, I'm handicapped.
Hereditary trustee, we can understand. Non-hereditary trust, what right he will have in a board? And matter of 2007.
No, nothing.
Many terms are over.
This was for which period? Nothing survives. This was for which period? Non-hereditary board is not for lifetime, right? It is for a limited tenure.
Your Lordship, I'm
When, no, nothing, no lordship. Yes, we will find out. Madam, please sit down. Don't time and appear and embarrass yourselves. We will decide it. Yes. Petitioner has died, that is taken note of in 7/11/2022. So there is nothing. When the period has come to an end, Mr.
Let's, there was a claim in the counterclaim, let's,
Huh?
it's pertaining to the founder family members. It pertains not only to the hereditary.
You also don't know, right?
I'm for the first respondent.
You also don't know anything.
Let's
All.
let. The dispute pertains to the founder family members. Who has to be recognized the founder family members, the 4 members. The petitioner has expired and a LR petition has been filed. The complete petition has been filed. That's even there is an interim stay by this honorable court in the appeal minutes.
What interim order? That nobody shall be elected.
49 IA.
Where you know,
49 IA, one of.
But what is this order? Interim order. What is the date of order?
Both No,
No, not.
no, second one.
Elder brother.
Direction HP number 1120 of 2008.
What did we say as very
This we are also doing states and certain accounting contributed to the disposal of benefits. And the single transference paid for.
pending disposal directly government to possibly float of
So the temple is situated running on the structure initiated for need to be declared to the disposal of the benefits. Means the different includes time. Protect the interest of the ministry and that every item of expenditure shall only be with the approval of the competent authority.
it has been restrained, right? On shooting of board of trustees. Ask her what is she? She will seek an adjournment.
This is the.
Yes, madam.
Lordship, may kindly grant on Thursday, Lordship, I'll prepare and come, your Lordship. I have not any money.
Madam, 3 days, Friday, Saturday, Sunday, enough for preparation. And today half day from 10:30 till 1:30 and even 2 hours there from.
Handicapped with one.
There's nothing to read the prayer clause. Please read the prayer clause.
Lordship, I'm handicapped with my bundle.
No, no, you don't have file.
No, your Lordship.
Great.
This is to Mr. Vijayasagar Services, senior counsel to Vijayasagar Services.
Who is CVC?
That senior counsel is coming, just make it right. It excludes the house.
Oh, yeah. Brother is telling that this temple is next to your house, correct? So what you should tell us? She doesn't have papers, you tell us what is the dispute?
The dispute seems to be between the brothers with regard to the Chanditri trust issue.
So,
in fact, one Mr. Yadagir Rao, advocate for the appearance, he just informed me that he is not well. He asked
this
me
is
to-
2007 petition, Mr. After 15 years, it's coming.
But one writ petition. I
We
think
feel
is
that
accepted.
we ourselves seek appointment as trustees of the life. We are so much interested in subject matter. She wants to keep it pending for next 50 years. She's 30 years till you are designated as senior counsel. 25 years. He doesn't want to say anything. We asked him any idea. He has no idea about the case.
Lords may take
So
up
it
next
has to-
week, Millard, I will ensure that something is.
But this is only petition. Petition.
LR petition is pending.
No, your Lordship, it is disposed of.
It's allowed.
Allowed, your Lordship.
One of the respondents passed away, that seems to have been.
No, no, this thing, it has been allowed. Respond number 4. Mr. G. Rajendranath Gaud.
Yes,
right?
he passed.
Now, so this is allowed.
Lords may take up next week or
Monday. Monday is what? 4th September.
August 24.
Learned Council. Madam, don't come on Monday, please, to this court.
Yes.
And come, you are most welcome, provided you are ready.
Yes, you.
If you are not ready, please do not come. Again, to pray for adjournment. Don't.
No.
You have got the right. We don't like young people seeking adjournment. We want them to argue.
Yes, your
So
Lordship.
very good, not a good court. We are telling you, not a good court for people seeking adjournment. Please do not come in case you are not ready. If you are ready, most welcome. Praise for adjournment. By way of indulgence, hearing is deferred. List on Mondays, 4 September 20. Forty-nine.
49 also go the boss like
48 and 49. 4th September.
from 50 to 59. Is a March child loan settlement that the date of the decision. to decide is. The registration. That is so quickly the proposition project will each month. 22
of registration. This is something that. Yes. Yes. Yes.
Keep 152 IPL. That's where virus subsection to be on the next challenge.
I am appearing for petitioner in item 58, man.
You are appearing for petitioners, right? 51.
Matters. AG is appearing in these matters, matters.
Let him begin, right? 10 minutes, 15 minutes at the most we can hear. So we can continue, right, tomorrow?
AG requested 2 weeks time, my lords, because the constitutional section 22A virus issue is involved.
2008.
Yes, it's pending. It's pending. Synopsis, you know,
Same thing, like whatever we told the lady appearing before.
I heard, my lords.
You heard, no?
Yes.
That applies to you also. You are a young person.
Yes.
So we don't, we just know what we told. We don't like young people seeking adjournment. So forget about AG. You have to argue since you are here. Forget about him. Why he appeared today in one case?
Yes, my lords. He requested time, my lords. Constitutional validity 22A. They challenge the virus.
But constitutional validity is challenged in 2007.
Yes, my lords.
13 plus 3, 16 years ago.
Yes. 2 weeks.
But you can see para 2 onwards.
This is Registration Act 22A. And bunches.
That is time.
Similar, some this thing validity of Stamp Act is also pending.
Yes.
Not to your knowledge. Not to your knowledge.
And that is memo matter. That is memo matter is different than the 22A is different.
Of course. No, we just inquired. Monday, Mr. Not beyond that. Mr. Counsel, Senior Counsel, Monday. Not beyond that. So and so prays for adjournment. By way of indulgence, hearing is deferred. List on 4th of September 23.
Much of life.
Keep that thing in staple.
May it please, Madam. Appear for the appellant. The respondent number 4 in the writ petition is the appellant before your lordships. The writ petition was allowed, my lord, setting aside the draft rehabilitation scheme that was sanctioned by the VIFR as proposed by the appellant. I'll just give a list of dates, my lord. With my lord's permission. In view of the subsequent legislative developments, where the Repeal Act was passed, repealing the VIFR Act, SICA Act, I'm sorry. Lord, the
Section 252 of the IPC code has been notified. Now, my lord, all proceedings are deemed to have continued under the IPC code before the NCL.
So grievance is still survives.
That view of the matter, my lord, the order of the learned single judge, setting aside the draft rehabilitation scheme and permitting the petitioner to once again go before the BIFR, my lord, no longer survives. The order to that extent needs to be set aside, subject to what my lords would say. Then, my lord, the respondent number 1, that is writ petitioner, may approach the, my lord, National Company Law Tribunal under section 31, my lord, as amended by the Repeal Act. Only for that purpose, my lord, I'll show the dates, my lord, subject to my lord's convenience.
No, but this company is no more, it's been wound up totally.
Beg your lordship's pardon.
This company has been wound up totally, DBR means.
Yes, my lord, it has, yes.
What remains then? What remains?
So, my lord, my lord, scheme for revival has been sanctioned by the BIFR, which was challenged by the promoter, by way of a writ petition. In the writ petition, my lord, the scheme was set aside. The order sanctioning the scheme was set aside to the BIFR, permitting once again the writ petitioner, my lord, to approach the BIFR with a fresh, my lord, scheme and depositing 50 lakhs.
In the meantime, as I know,
In the meantime,
the company totally,
the
assets have been liquidated.
company, my lord, I don't know, with respect to that, my lord, my suggestion is
DBR
there is a status quo.
Hyderabad, Warangal, everywhere, it
This
has
is-
been liquidated.
Yes.
The land of DBR mills is allotted to something
Right now,
else
my lord,
also.
that's not the condition, my lord, I have found out, because there is an order of status quo granted by the division bench. My lord, as far as the property is concerned, I don't think that's an issue, my lord, but the question is, my lord, the legislative interference and change, my lord, in the situation by repealing the SICA Act. Only 5 dates, my lord, subject to my lord's convenience. I'll show to your, my lord, I've just passed on. The respondent number 1, my lord, was declared as a sick industrial company under section 15 of the Act. And the respondent number 3 was appointed as operating agency for rehabilitation of DBR mills on 8/10/1987. On 2/12/1994, BIFR formed opinion that respondent number 1 should be wound up under section 20 and directed issuance of public notice for considering the objections and suggestions or alternative proposal, if any, from anyone. On 31/3/1995, appellant proposed a scheme for revival of respondent number 1 company to BIFR. In May 1995, appellant deposited 50 lakhs to prove the bona fide. On 28/5/1997, the proposal of the appellant to revive the respondent 1 company was circulated as draft rehabilitation scheme under section 18.
One second. Anything survives in this because as I recollect, the entire company assets have been liquidated.
The company is not out of the company is there. So my respected submission not the pay subject to what the other state say. By virtue of the repeal of the SICA, which came into effect in 2016. The cases of those companies where the sanctioned scheme is there and it has been put into implementation, those all are saved at the IBC, Schedule 8 of the IBC. The rest of the cases, it says that they stand abated. In this case, the sanction scheme has been set aside by the learned single judge. And by virtue of that, by upper subbasis, that proceeding stands abated. By virtue of the repeal of the Act and subsequent provisions of the IBC.
IBC.
On 28/5/1997.
Insolvency and bankruptcy.
I have filed, I'll show the compilation. On 28/5/1997, the proposal of the appellant to revive the respondent one company was circulated as draft rehabilitation scheme under section 18 of the SICA Act 1985 by the BIFR. On 3/5/2007, the proposal of the appellant was sanctioned by BIFR. This order, my lord, came to be challenged by way of the writ petition, my lord, order which is under appeal. On 8/2/2008, the WP 1173 of 2007, filed by respondent number 1, was allowed by this honorable court. On 12/4/2008, status quo ordered in Appeal 391 of 2008. On 1/1/2004, the SICA Act was repealed by Parliament. On 1/11/2016, Section 252 of the IPC 2016 was modified by the central government. On 24/5/2017, proviso to Section 4B of the SICA Repeal Act inserted to save the scheme sanctioned by the PF. Now, my lord, I'll just pass on, my lord, the modifications under the IPC Act. have your lordship's permission to pass on.
No, Rashekar, tell us one thing. Which is the scheme that is actually subsisting, which stands saved by virtue of the
That
repeal?
is what I wanted to show to your lordship.
That is. ఇది కదా నువ్వు చిన్నది ఐబిసి పొన్ను చిన్నది ఉండాలి.
The 50 lakh ballot is at page 22 of the appellation that I have just now handed out. May I invite my lord's attention to page 23, section 4 of the repeal act. Kindly go to page 24, where the proviso was added, my lord, on 24/5/2017. Page 24, my lord. May I read?
Yes.
Provided also that any scheme sanctioned under subsection 4 or any scheme under implementation under subsection 12 of section 18 of the Act shall be deemed to be an approved resolution plan under subsection 1 of section 31 of the IBC Code 2016, and the same shall be dealt with in accordance with the provisions of part 2 of the said code. Remember, what happens is, by virtue of this removal of difficulties order and insertion of this proviso, what is saved, my lord, is a scheme, and it shall be deemed to be an approved resolution plan. My lord, the scheme that was sanctioned by the BFR was 3/5/2007, which was set aside by the learned single judge, which is under challenge. That judgment is under challenge before your lordships. The learned single judge, my lord, while setting aside, also said, may I invite your lordships, kind attention to the order of the learned single judge, the implementation portion at para 26, page 25 of the writ appeal. In view of the aforesaid facts and circumstances of the case, and for the reasons as stated above, the impugned order is set aside and the matter is remitted to BIFR, permitting the petitioner to submit its suggestions as contemplated under 18(3)A, read with 18(1)A of the SICA within 30 days from the date of receipt of a copy of this order, by making a deposit of 50 lakhs with the BIFR towards settlement of part claims of workers to test its bona fides. On such deposit of 50 lakhs, it is open for the BIFR to direct the operating agency to disburse the said amount of this
This
order.
provision is subsequent, Mr. The scheme was.
Yes, my lord, it is subsequent to remove the difficulties where schemes are sanctioned. Now, my lord, what happens is.
Mr. You said that learned single judge has set aside the scheme, right?
Yes, my lord.
So that scheme was set aside.
The impugned order is set aside.
2008.
Yes, it is set aside.
Then?
Yes, my lord. The order of the learned single judge is under challenge. Now, what happens is.
Now you are referring to a saving clause in 2014 and saying that it revives.
Kindly.
That's a query for you.
Yes, I understand. I understand.
This case should not take this long,
My lord,
right?
this order of the learned single judge is now unimplementable. Now, kindly see the situation in which the appellant is placed. My scheme, my lord, is set aside.
No. So this whatever page 24 doesn't apply, right?
It applies, my lord.
No applies.
My lord,
Read it again. Provided.
Yes. I have seen
This
that.
has.
2017 proviso is added for removal of difficulties. That is the difficulty which we are facing. That is why the proviso has been added. My lord, is my respectful submission before your
Proviso is added in the year 2017.
Yes.
That does not apply with retro effect in respect of the Parliament cannot set it, not the order passed by learned single judge. Please understand.
But this is a.
You are saying that by this thing, by this proviso incorporated on 24/5/2017, order passed by learned single judge setting aside the scheme has disappeared into thin air.
It's not what I am submitting. My respectful submission before your lordship is the order passed by the learned single judge is unimplementable in view of the repeal of the SICA Act. Now, kindly, my lord, visualize the situation in which the appellant is placed. My lord,
So we have understood unimplementable, therefore.
Implementable.
Therefore,
This order.
It should be set aside.
Yes, in the order of the learned single judge should be set aside.
All right.
And my lord, the respondent number 1, then my lord, what is revived is the fourth proviso to the Repeal Act, under which my lord, he has to go under section 31 before the IPC code and pursue his remedies. Kindly see,
All right.
my lord, see my situation where.
Fine.
But that is my respectful submission for your lordships.
Subject to what senior counsel has to say. Yes, please.
Yes.
Anything else?
On merits of the matter, my lord, I have not made submissions in view of the subsequent developments.
Of course.
Act is repealed.
Of course, of course.
But that's what I want.
As I was submitting to Lordship, by virtue of the repeal of the SICA and by virtue of the provisions incorporated in the Companies Act and subsequently in IPC, what was saved was only the schemes which are sanctioned already and also the schemes which are put into implementation. The provision Lordship has just now seen. So this is a scheme. The proceedings of the BAFR dated 3/5/2007 have been set aside by the Learned Second Judge in the inspection. By virtue of that proceedings, the scheme was not totally sanctioned. The paper book number 2 filed by the Learned Council for the appellate. This 3/5/2007 order you not will get it. BAFR merely said that last paragraph of the order, the bench further directed that the operating agency IFCI to incorporate the above changes in the draft rehabilitation scheme circulated by board's order dated 28/5/1997 and submit the same to the board within 15 days along with the 2 floppy CDs for issuing the sanction scheme. So sanction scheme was not yet issued. Some modification, some changes were sought to be incorporated in the earlier set aside scheme and the operating agency was directed to incorporate them and submit to the BAFR so that the BAFR issued sanction scheme. This order of the BAFR has been set aside by the Learned Single Judge. So, my lord, there is no sanction scheme in existence as on date, my lord, the Learned Single Judge passed order, nor as on the date, my lord, on which the amendments have came into force. The repeal of the statute and subsequent, my lord, saving clauses, etc. My lord, I mean, there is no sanction scheme as on that date. Had there been a sanction scheme, my lord, perhaps, I mean, this provision, etc., would have saved it, my lord, it's a different line of argument. In my respectful submission, there is no sanction scheme, and by virtue of that, my lord, I mean, being set aside by the Learned Single Judge in 2018. And 2016, subsequently, my lord, this saving provisions, etc., come into force. My lord, there is no sanction scheme in this case. So, my lord, I mean, nothing is saved. Everything stands related.
Yes. Yes, Mr. What abatement submission?
Yes.
You have heard it.
Petitioner understood it to be sanction scheme. That is the whole case of the writ petitioner. May I invite your lordship's kind attention? The writ affidavit, my lord, where it is asserted that the scheme has been sanctioned without hearing him. That's his case.
Yes.
The petitioner's case in the writ petition is that the scheme has been sanctioned without.
No. What do you say that the sanction scheme was there when this 2016?
Yes, 3/5/2007, there was a sanction scheme which was set aside by the learners.
All right. That we have understood.
Yes. Yes.
That's it. So what is it has not abated because petitioner understood that sanction scheme survives.
That's what. There is no question of abatement, my lord, because the order of the single judge is under challenge in the writ petition.
But it will depend on the interpretation of statutory provision, not what petitioner understands, right? He may not have met the senior counsel before understanding. So then lighter weight at 440, we can only say this. Then he must have realized what is it. Correct? This, yes. We will pass an order. Today it's a order. Acha, reserve. Okay.
Public.
Thank you. All right, so we will pass an order.
Very well.
It's not, it will not come separately. Today it will be passed. Tomorrow the copy may be available for you. It's already. Right?
Yes, sir.
So remaining cases continue. Vote continue.
One moment.